work of the team in recent months. So we're sad to see Mark go, but we're delighted to have Stephen, and we'll wish both of them all the best in their respective roles now. So I'm going to call the meeting to order. We're in public, Aaron? Yes, that's great, thank you. Members, welcome to the 30th committee meeting of the Committee for Justice. The meeting is now open to the public. I'm not sure, Aaron, is there anybody to come into the gallery? Then we're clear, that's fine. Members, the committee meeting is going to be recorded and broadcast throughout Parliament buildings and online. It's proposed that the oral briefing from the Assembly's Research and Information Service on the proposed amendments to the biometrics part of the Justice Bill, the oral evidence session with the Scottish Biometrics Commissioner on the biometrics part of the Justice Bill, and the oral evidence session with departmental officials on the proposed statutory rule relating to electronic monitoring requirements will be recorded by Hansard. Are members agreed? Yeah, thank you. Also, members, just as usual, we're obliged to declare financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare in relation to today's proceedings should do so now or when the particular matter arises in the meeting. Do members have any interest to declare? Deirdre?
Yeah, just an immediate family member who works in the court service.
Thank you. And I've an immediate family member who works in the legal profession. Danny?
Yeah, family member, probation board.
Thank you. And then there's a few of us who are members of the APG on access to justice. Yep, that's Connie, Ciara, Deirdre, me. Right, that's us covered with that. Agenda item 1 is apologies. I don't have any apologies. Is anybody else aware of any? No. Thank you. And then you can see, members, that we've got Danny, Ciara, Doug and Deirdre online. Agenda item 2 is draft minutes. Those are minutes of the meeting we held on Thursday the 13th of February, and those are pages 5 to 12 of our pack. Are members content that those minutes are a true and accurate reflection of the meeting on the 13th? Yes, thank you. Then I'll sign the minutes. Agenda item 3 then is matters arising, and we've got a couple. Item 3.1 and 3.2 are with regard to the Department of Justice and Department of Health correspondence on the Cresswell review, and I would ask members to turn to pages 14 to 28 of your pack for the relevant papers. You'll see that the DOJ has provided a copy of the terms of reference for a bespoke review of the Cresswell case, and the department states that as Jonathan Cresswell was never referred into or managed under public protection arrangements in Northern Ireland, Papani serious case review, which would examine the way in which someone was managed under those arrangements, is not possible. So an independent reviewer, Jan Melia, has been appointed to undertake the review, which is expected to be completed within a 6-month period. The department has advised that Prison Service, Police, Probation Board and the Western Health and Social Care Trust are going to be engaged in that review, and other agencies represented on Papani or the Multi-Agency Risk Assessment Conference may also be invited to participate in that at the discretion of the reviewer. Just to advise you members that the Minister of Health has confirmed that participation of a representative of the Western Health and Social Care Trust in the review, but he did advise that the Department of Health was not cited on the draft terms of reference. So can I seek your views on the terms of reference and whether or not you're content to note the terms of reference and the response from the department, or do you require any further information or clarification? Has anybody got anything? Deirdre, you indicating? Go ahead.
Yeah, no, it was just no thanks. And obviously, I mean, this is a step forward in terms of the review and obviously the individual that's been selected to lead it. I suppose for me, it's just what the engagement of the other sectors and agencies, you know, the level of involvement, even if we can be kept updated, you know, in terms of are they engaging? Because as was raised before, you know, particularly the health, there appears to be failings, and just to satisfy ourselves that that's going to be looked at. And the other bit for me is, I mean, I raised this at the last meeting where we discussed this. It isn't just around the deceased, Katie. There may have been other young people that would have interacted with this individual And it's just making sure, you know, is the reviewer going to try and look at that as broadly as they possibly can, in terms of making sure that we can try and avoid anything like this happening again. So maybe we can just, you know, get updates when it's possible, of the level of engagement across those other agencies that have been named.
Well, I think that's fair enough. I'm sure we'll agree to take that forward. I mean, I had a couple of things myself around this about, I suppose, missed opportunities with other females and whether that would have been indicative of a pattern of behaviour. The other issue is, I suppose, around whether they're just looking at direct contact between Katie and and her murderer, or whether indirect contact is also involved in that process. And maybe the department could provide us with some clarification on that. Are members content with that we flag up those issues to the department? Yeah, that's great, thank you. Item 3.2 then, under matters arising, is a visit to the court service, and I would ask members to turn to pages 29 to 42 of the meeting pack for the relevant papers. I think every member who was there enjoyed the visit. It was informative and useful, and we also took evidence in terms of the bill. So you'll, just for those who weren't there, we received an overview of the Themis programme, and that's going to be rolled out to all parts of the court system over the next 5 years, as you can see from the presentation which has been included in your packs. It's an impressive programme which should transform services for staff, the judiciary and stakeholders right across the courts and tribunals system. And the committee also received a demonstration of SiteLink, and that was quite useful. That's the technology that will underpin the use of live links in courts and tribunals. We then had a tour of the Royal Courts of Justice and an overview of the plans for its modernisation. I think some of us were quite shocked about the state of some of the kind of the things in the background of the Royal Courts of Justice, and saw with our own eyes the requirement for works to be undertaken. You'll see from what you have in front of you that the plans are ambitious and are going to require the refurbishment of the old town hall, which members also had the opportunity to visit. And all of that, anything pertaining to the visit, has been included in the meeting pack. Are members content to note the papers? Thank you. Agenda item 3.5 then, sorry, this is still matters arising, isn't it? Is committee response to the draft budget, and I would ask you to turn to pages 3 to 12 of your tabled pack for these papers. You'll remember that the Committee for Finance had requested that responses from committees to the draft budget 2025-26 were submitted by tomorrow. That's the 28th of February. So in order to do that, we would need to approve our submission, and you'll see that a draft response has been prepared and is included in the tabled pack for your consideration. Do members have any comments to make, or do you wish to propose any amendments to the draft? Members content? Yes? Thank you. Right, on that basis then, the officials are going to issue the response to the Committee for Finance. I don't think, if we're not agreeing on any amendments, then it'll go as is. Okay. Agenda item 4 is the Justice Bill Biometrics Assembly Research and Information Service oral briefing. So I'd ask you all to turn to pages 43 to 101 of your meeting pack, and also pages 14 to 22 of your tabled pack, where Judith's presentation is. So members, with us at the minute we have Judith Bailey, who's a researcher with the Assembly's RAISE division. So Judith is going to provide us with a briefing on the amendments on the Justice Bill with regard to biometrics. Judith, thank you. It's great to have you with us again. We look forward to hearing what you've got to say. We've read your presentation and so on. So I'm going to hand over to you, and then we'll open up for some questions. Thank you. We're having some technical difficulties here. Is this about putting the presentation on the screen?
Well, I mean, I can just talk through it. And I think
we
you have a copy of it
anyway,
in your packs.
Yeah.
So, yeah, hopefully you can follow along with as I go. I think it's in your table pack, so
yes.
You should be able to see it there. So yes, I'll crack on. Anyway, thank you, Chair, for the invite to address the committee on the Justice Bill this afternoon. So as you said, today I'm going to look at part 1 of the bill covering retention periods for DNA and biometric material in more detail. So I'll be aiming to go through the bill as drafted to highlight the impact of the proposed legislative changes and some potential areas for further scrutiny. And the Department has also brought forward a number of amendments to the bill, which will be introduced at consideration stage, and I'll do my best to give an overview of these as well. So I know the committee has a busy agenda today, so I'll try and cover the biometric data proposals as succinctly as possible. But as you know already, biometric data is a complex and developing area with different legal frameworks and oversight arrangements in operation in other parts of the UK. And I'm sure other stakeholders will be able to provide useful insight into this as well, including the Scottish Biometrics Commissioner, who you'll be hearing from later on. So, first slide in my presentation covers a bit of background about what biometric data is, as well as some of the developments relating to the Marper and Cochrane European court cases and developments since then. So I did cover most of this previously when I was here in September talking about the bill, but Chair, is it useful for me to cover this again for the committee? If not, I'm happy to skip on to my next slide and just get straight into the bill, but I can also do...
Members, what do you want to hear? You can tell that you've got the background sufficiently.
If it's okay, I would like to hear, if it's not too much trouble.
That's all right,
No,
Donna,
absolutely, that's perfect.
No, it's important to hear
Grand.
everybody's up to speed, as for now.
So, first of all, what is biometric data? Well, generally, it's the term used for fingerprints as well as DNA profiles. And these are unique identifiers derived from a physical sample of DNA, which might come from blood, hair, saliva, etc. Biometrics can be used to identify a particular individual and are routinely used by the police as an important resource in all kinds of criminal cases. So, the existing legal framework in Northern Ireland is found in Article 64 of the Police and Criminal Evidence Northern Ireland Order 1989, and this allows for the indefinite retention of biometric materials, including DNA samples, profiles, fingerprints and palm prints. So biometric data retention is an area in which there's a need to consider Article 8 of the European Convention on Human Rights around the right to respect for private and family life. In recent years, there have been 2 European Court of Human Rights judgments relevant in this area. The first was S and Marper in UK back in 2008, and this considered the retention of fingerprint and DNA data of 2 people suspected but not convicted of offences in England and Wales. And the court considered that the blanket and indiscriminate power of retention was a violation of Article 8, particularly given the absence of any time limit and lack of any independent review mechanism. So this case was followed by Cochrane and UK in 2020. And this case involved an applicant with a spent conviction for driving with excess alcohol in Northern Ireland. And the European Court held that there had been a violation of Article 8 due to the indiscriminate nature of the powers of retention of the DNA profile, fingerprints and photograph of the applicant. Again, the lack of any possibility for review was highlighted. So during this period, the Criminal Justice Act Northern Ireland 2013 aimed to create a compliant retention regime. However, it was not possible to commence the biometrics provisions due to the need to preserve material that might be required for future legacy investigations. So then, separate from the Justice Bill, regulations made by the UK government, which came into force in May 2024, provide for the retention of biometric material that otherwise must be destroyed under various statutory destruction provisions. So this material is for use only by the Independent Commission for Reconciliation and Information Recovery in conducting investigations. And these regulations also require the Commission to carry out periodic reviews of the need to retain the biometric material and require that biometric material be destroyed if it's no longer needed. So at present, the PSNI has an interim service instruction on the retention and deletion of biometric material, and the service operates a biometrics ratification committee, which will consider applications for deletion from both local and national biometrics databases. So the likes of the National DNA Database, the local Northern Ireland DNA Database, the National Fingerprint System and paper sets which are held locally in the PSNI Fingerprint Bureau. There's also a police national database which holds custody photos. And deletion requests will cover an applicant's DNA samples, DNA profile derived from any sample, fingerprints, palm prints, as well as any custody photographic images. So I'm on to my next slide if you're able to follow along. Part 1 of the bill follows a consultation by the Department of Justice in 2020, which focused on the maximum time periods for the retention of biometric data. This has resulted in a 75, 50, 25-year model, which is reflected in the bill. So this means a 75-year retention period for DNA and fingerprints for convictions for all qualifying offences. So these will include serious violence and sexual offences regardless of age. And this is followed by a 50-year retention period for adults convicted of non-qualifying offences with a custodial sentence of 5 years or more. Then there's a 25-year retention band for adults convicted of non-qualifying offences where there's been no custodial sentence. And there is specific provision for under 18s as well, with retention periods based on whether a first minor offence is applicable. So I suppose rather than me talking through every retention band, because there are multiple variations depending on a range of factors, Table 1 in the raised briefing paper in your packs covers these. What's on the slide at the minute just sort of is a kind of high-level overview of 3 of the kind of different retention scenarios. But I suppose one of the new amendments brought forward by the Department relating to retention periods for individuals who have completed restorative justice schemes is relevant here, as it inserts a new Article 63NA into this part of the bill. So the bill as currently drafted includes restorative justice schemes within another article which also covers diversionary youth conferences, and the amendment separates these both out and is designed to recognise that the Public Prosecution Service can direct the use of restorative justice schemes for both adults and under 18s. And under the amendment, they will attract the same retention period as a caution for adults, so 75 years for a qualifying offence or 25 years for a non-qualifying offence and 5 years for an under 18. More broadly, the committee will be aware that a number of recent reviews of the justice system have recommended new statutory provision for restorative justice for over 18s, including the Department's review of sentencing policy. So it's possible in future that if there's further legislative change through the likes of the sentencing bill, we could see court-ordered restorative justice used more widely within the justice system. So on to my next slide, if you're following. Also just want to talk about Article 63G in a bit more detail, which provides that if a person is charged with a qualifying offence but not convicted, then police can retain their biometric material for 3 years. So the process is highlighted on the slides, but no application to the Northern Ireland Commissioner for the retention of biometric material is required in these circumstances. However, the PSNI can apply to the Commissioner for a 3-year retention period for individuals arrested but not charged with a qualifying offence and where prescribed circumstances apply. So this part of the bill provides for regulations to be made about the prescribed circumstances which may apply, including the procedure to be followed in relation to any application to the Commissioner. So these regulations must be laid before and approved by a resolution of the Assembly before coming into operation. Also, just to highlight that a power to extend retention for a further 2 years in the 2 scenarios I've just referred to in this slide can be found in Article 63H, where the Chief Constable makes an application to a district judge. So since the bill was introduced, the Department has brought forward amendments relevant to this section, and one of these adds a new sub-paragraph into Article 63G to clarify that material can be retained by police until proceedings on the application to the Commissioner have been concluded. There is also a change to Article 63E of relevance. This currently provides a grace period of 14 days for DNA and fingerprints being held for individuals under investigation, and this is being increased to 28 days in order to allow the PSNI adequate time at the conclusion of an investigation to delete these from the relevant databases or apply to the Biometrics Commissioner for continued retention. So on to my next slide. And this leads on to another part of the bill relating to the review of retention of material pending investigations. So biometrics relating to an individual subject to an investigation for an offence can be retained until the end of investigation or any criminal proceedings. But Article 63T of the bill highlights a requirement for the Chief Constable to review the continued retention of material pending the investigation of offences every 5 years. So this must consider whether an individual remains a suspect in the investigation and whether the biometric material has evidential value in the investigation or any proceedings. So the department may make regulations specifying further factors which the police must have regard to in conducting a review, and these regulations must be laid before and approved by a resolution of the Assembly before coming into operation. So the Gaughran and UK case that I spoke about earlier highlighted the importance of a review mechanism as an essential safeguard within a biometric retention regime. And Article 63U of the bill requires the Chief Constable to conduct reviews of the continued retention of long-term retained material where this is held for 25 years and over. The detailed arrangements around this will be contained in regulations which the department must provide for, and these must be laid before and approved by a resolution of the Assembly before coming into operation. However, this may cover a range of matters, such as when the review should be conducted, enabling the individual concerned the right to request a review, and conferring a right of appeal. Any role for the Biometrics Commissioner in assessing individual applications also seems to be left to be defined in regulations. So I know the committee has already taken evidence from the Northern Ireland Human Rights Commission on the bill, and that they highlighted a range of potential further considerations around the review mechanism which could be defined in the bill, such as whether the proposed Article 63U should set out the time frame for periodic reviews of biometric material, a duty on the Chief Constable to consider the proportionality of the retention of a person's material, and whether further provision for the right to appeal a determination by the Chief Constable can be included in the bill. So these are all things potentially worth consideration by the committee. So on my next slide, I've already touched on this, but the Justice Bill provides that the department must appoint a commissioner for the retention of biometric material. So the Commissioner also has a specific role in relation to keeping under review the development of existing and new biometric technologies which might be used by law enforcement authorities for the prevention and detection of crime. There are a range of emerging policing methods which may be of relevance in this area. For example, live facial recognition technology. 6 police forces in England and Wales have used this to date, but it has not been deployed by Police Scotland or PSNI, I believe. New developments in other areas such as voice analytics, gait analysis and AI-driven surveillance technology are likely to progress significantly in the coming years, and it will be necessary to consider the implications of this for any legislation governing biometric data retention. Earlier, I highlighted that there are different oversight arrangements for biometric data retention in other parts of the UK. So we have the Home Office Biometrics and Surveillance Camera Commissioner, although this post is currently vacant, and the Scottish Biometrics Commissioner, who you're hearing from later. So it may be worth exploring how rapid changes to biometric technology are already impacting on existing legal frameworks in other parts of the UK, and what we can learn from this to help inform our own Justice Bill. So on my next slide, I've already referenced some of the amendments that the department has brought forward to the Justice Bill in the course of my presentation. These next amendments relate to the power to photograph certain persons at a police station. At present, the existing legislation gives the PSNI the power to take photographs from a person who's been detained in a police station or arrested. However, there is currently no power providing the PSNI with the ability to require a person to attend a police station at a later stage for a photograph to be taken. So these amendments seek to rectify this, where a person is arrested or charged, and provides that one of 2 conditions must be met. So these are that either the person has not been photographed in the course of the investigation of the offence by the police, or the photograph is unavailable or inadequate. So there appears to be a time limit of 6 months for police to then take the photograph, and there's also similar provision for individuals convicted of or given a caution in respect of a recordable offence with a time limit of 2 years. So then we also have another amendment which gives the police the power to specify a date and time for attendance. So people who are arrested and taken to a custody suite will generally have fingerprints, DNA samples and a photograph taken straight away, but there might be cases where this is not possible. So at present, a person can be required to attend a police station at a particular time, but not on a particular day, only any day within a 7-day period. So the amendments put photographs on a similar footing to DNA and fingerprints in terms of the recall power to specify attendance. They also then give the PSNI the power to specify a date and time for individuals arrested, charged or convicted to attend a police station for fingerprints, samples and photographs to be taken. So in practice, this will allow opportunities to take fingerprints, DNA and photographs to be maximised, which will potentially help to detect crimes that an individual may have committed in the past or may commit in future. However, the committee may wish to consider getting further detail around how the PSNI will operationalise the power. More broadly on custody photographs, the last time I was here before the committee, I highlighted that the Justice Bill doesn't explicitly include custody photographs as being biometric data and currently just covers fingerprints and DNA. So departmental officials before the committee in January highlighted that they still have not reached a view on whether photographs are biometrics, and that this is still an evolving issue which requires a bit of further work. So slightly different approaches are taken around custody photos depending on which part of the UK you're in. So for example, Scotland's definition of biometric data does include photographs and recordings alongside fingerprints and DNA, but this is not the case in England and Wales. Again, it's just something for the committee to consider exploring further with stakeholders as scrutiny around the bill progresses. And the last amendment to Part 1 of the bill that I want to highlight is a change of terminology to parts of the existing legislation relating to biometrics. So these change the term reported to a complaint being laid against a person. So there seems to have been some confusion around the meaning of the term reported for an offence and how this then relates to the operational procedures across the biometrics provisions. So the amendment remove references to reported and change this to reflect that a person being charged with an offence includes where a complaint has been laid against a person. So this means that references to a complaint being laid against a person covers a complaint being made that the person has or is suspected of having committed the offence without having been charged with that offence. So really aligning with the Magistrates Court's Northern Ireland Order 1981. Finally, the committee will be aware that the department has said the biometrics amendments do not represent any significant new policy and came about from stress testing with PSNI operational colleagues. So in terms of further scrutiny on the biometrics amendments, it may be worth considering any engagement the department has had with stakeholders such as the Human Rights Commission or the Information Commissioner's Office on these, and further consideration could also be given to whether there's been any progress around providing a projected cost around the biometrics provisions, including any impact that the amendments might have. So you'll be pleased to hear that's the end for me, but I'm aware you're hearing from an actual expert in all this with the Scottish Commissioner up next, but of course I'm happy to try and answer any questions that you might have on this part of the bill.
Yeah, thanks very much. I'm going to open up to members now, and as you've heard, I've got a few here. Oh no, actually I didn't have any for you. So does anybody, having heard that, does anybody have any questions for Judith? Are you saving it all up for Dr. Plasto?
Just one point of clarification, if
Yes,
possible,
Maurice.
Judith. Reported for an offence and charged with an offence where a complaint has been laid. Could you sort of break that up a wee bit for me? The application of DNA and fingerprint and retention. What's the difference?
So I think at the minute the terminology reported is used in a number of places in the legislation, and I think there's been some confusion around that term is used differently in different parts of the system, so it can mean different things at different points, and it maybe was just necessary to clarify that, and in relation to when biometrics can be taken from an individual. So a complaint being laid aligns it more with the existing legislation in the Magistrates Court, and then that hopefully, I don't think it's, it's really just a change to the terminology rather than...
Streamlines it so that...
I think so, yeah. I mean, there's a bit more detail kind of around it in the written paper itself, just... see if I can find the relevant section. Let's see.
Are they at different stages of the process, Judith? So essentially reported is when somebody's reported to the PPS by the police, is that it? and the other one is when a complaint
Yes.
is made, which means when a person comes in and says such and such did such and such. Is that,
Yeah,
is
so I
that
think-
the
I
distinction?
think it was at the PSNI had indicated that a person that once the PPS takes the decision to prosecute, that a person is deemed to be informed that they have been reported, and so that change in terminology and changing it to where a complaint has been laid against a person just means that it's sort of taken it a bit earlier in the process and sort of streamlines it and makes it more.
It's the point at which somebody goes to the police, as opposed, or which somebody's brought in by the police in the course of an investigation, as opposed to the point at which they're already charged and reported to the PPS.
Yes, I sort of
So it would be part of the investigation, not
Mm-hmm.
as a
Yeah, not once
consequence
they've
of the outworkings of it.
Cheers, Maud.
Does that help
Yep.
you?
I appreciate that. It's quite a technical point, really, isn't it? But
Justin?
Thanks, Chair. Thanks, Judith. A lot of heavy lifting done there, Judith, in terms of the detail. In relation to biometrics, your presentation is very Scotland, England, and UK heavy, and I'm just concerned and interested to know how has Brexit changed things in terms of adherence to the ECHR or otherwise, and how do the proposals compare and contrast to existing arrangements on the entire island of Ireland, including the south of Ireland?
Sure. Well, I had, I think I previously provided a bit of an overview in relation to the system in the Republic of Ireland. So there is another paper in relation to that. If that's useful, I can provide that again to the committee. But yeah, so in terms of the Republic of Ireland, there is a piece of legislation, the Criminal Justice Forensic Evidence and DNA Database System Act 2014, which governs biometrics in relation to policing there. So, and that has a number of sort of retention periods for biometrics set out within it, and so there are sort of specific retention periods for offenders, also individuals suspected of offences, and then specific retention periods for children as well. There isn't a similar sort of commissioner type role in the way that there is in Scotland or England and Wales, but they do have a DNA database system oversight committee which oversees kind of the management of the system there. So yeah, that's sort of a bit more about what happens in the Republic of Ireland.
And how does that align across the islands? What compare and contrast both? Is not be more rational for us to align more closely with the south as opposed to somewhere where there's a sea separation?
Well, so I think certainly so for offenders in the Republic of Ireland, the retention period is indefinite, really. So they have indefinite retention there for individuals who have committed offences. But which I think at the time when the legislation was passed, the Irish Human Rights and Equality Commission had sort of outlined some concerns around that. But there are differences in relation to child offenders as to what system we seek to sort of put in place in Northern Ireland. I'm not sure it's really for me to comment on where exactly we should be following, but
That's fair, Judith. I appreciate your answers. Thank you. Thank you, Chair.
Point, Judith, so that means that we're undergoing this because we've been found to be in breach of the European Court's conventions, but the Republic is also in breach of the European Court's conventions if they're holding DNA indefinitely too.
Well, there does appear to be the provision for that in their existing legislation that information can be retained there indefinitely. I don't, I'm not sure whether they have any plans to make any further sort of changes around that, but that is the system as it currently exists.
Okay, thank you. Deirdre?
Yeah, no, thanks very much, Judith, so far. I suppose feeding on from Justin's point, because the bit I was going to ask is the Human Rights Commission raised this more so around the European directives now as a result of the Windsor Framework Agreement. So it's just if there's been any scoping or work done in terms of, sorry, I'm just trying to get it here in terms of the bit that they highlighted in terms of the EU Law Enforcement Directive. So just around, is the framework compatible? Does it comply with that directive? So I don't know if there's any research or anything that will point in terms of what the directive is, but I know it's something that the human rights, or maybe it's a question that we could ask the department to give us clarity on. Do they have assurance that these changes do comply with that European directive under the Windsor Framework? So it's probably an area that we could be asking the department. The other bit, Judith, in your presentation on the review period, particularly for information being held over the 25 years or more. I know you talked on, it mentions twice in terms of, factors that the Chief Constable would consider would be left to regulations, as would the next period. Does that not leave a gap in the intervening period? Because obviously we've been looking at post-legislative scrutiny and regulations that haven't been moved, where funding has been given as an issue as to why certain regulations and previous legislation haven't been brought forward. But in terms of that review, because that's again one of the areas I know a lot of the stakeholders have been raising in terms of that right to appeal, the right to review how your data is held. But if we're going to leave that to regulations, there's no date in this legislation. Sure, there's not on when those regulations should be moved. So I'm just wondering if they weren't moved in tandem, with the commissioner and stuff being set up, does that not leave obvious gaps?
I can't really comment on when the regulations would potentially be moved or commenced. I don't have any further information around that at this point in time.
There's no commencement dates in it, but sure, there's not from memory. There's not, sure. It just says they will be commenced at a future.
Yeah, I would need to just check that now, but
okay. It's just an area, again, I suppose, with the department then we need to pick up on in terms of any potential gaps then if regulations weren't to move, that could create around this area, because that's what I would be concerned about. Thank you.
Thanks, Judith. Does anybody else have anything for Judith? I have a couple of points just. Judith, part of your report refers to England and Wales are given, under the previous government, were kind of looking towards changing their system and doing away with the post of a commissioner. So they would be, is that still in the offing? Have you heard? Is there anything indication from the Labour government what they're intending to do?
No, there isn't at present anything that I've seen in relation to it. So yes, there was a data protection bill that fell just ahead of the last general election. So I think in the King's speech there was reference to potentially another data protection and maybe smart data bill brought forward, but no information as to what might be included in that and whether this, the changes to the Home Office biometrics commissioner, whether that will be brought forward again. I don't know. Maybe one to potentially ask the department whether they've had any engagement around that with the Home Office.
Yeah, I think we might do that. And the other aspect of that was that some of those responsibilities were going to go to, let me just get to the right page 55, section 3. Yeah, some of the commissioners' work was going to go to the Investigatory Powers Commissioner. Mm-hmm. Do we, and that office, do we know where the other powers were going to go, or what was going to happen to them? No.
I don't have any detail around that at the minute, but
no, I just want us to be clear. There's jurisdictions now doing away with it, and we're about to set one up. So I would like to have some understanding around that. That's fine, Judith. I think anything else that I have, I can save for the commissioner himself. If we have anything else, Judith will follow up with you. Are you intending to stay for the next session so that you can hear? Or you're welcome to. Yes, there's no pressure, but you're welcome to. All right. Do members have anything else? No. Content to move to the commissioner for biometrics in Scotland? Yes. All right. Thank you. I understand the commissioners are coming in person. Judith, thank you very much for that. That's really helpful. I'm sure we'll have more for you as we progress, but thank you for that so far. Members, agenda item 5 then is us receiving oral evidence from the Scottish Biometrics Commissioner, and I would ask you in advance of that to turn to pages 102 to 157 of your meeting pack. Just before we move into this session, could I also ask, you'll see at is it page 105? Certainly there's a series of questions. I think, didn't Judith table a series of questions? Yes. Would members be content that we would submit the questions from Judith and those that have been raised here today to the department so far? Yes?
Yeah.
Is that okay?
Yes.
Thank you very much. That's great. Just it means we'll be getting a bit more additional information. Dr. Plasto, you're very welcome. Thank you so much for taking the time and certainly to come in person to give us some evidence. We're really looking forward to hearing what you have to say as we wrestle with these issues. We've received your paper. We're going to hand over to you, and then after that there'll be some questions around some issues about how operationally it's working for you in Scotland, reviews, children and young people, what we could learn, the distinctions between the jurisdictions, and other bits and pieces along those lines. So that's where we're coming from, but for now I'll hand over to you, and thank you very much.
Thanks, Chair. I'm Brian Plasto. I'm the Scottish Biometrics Commissioner. You don't have to be Scottish to be the Scottish Biometrics Commissioner, but I am, so I apologise for my accent at the start. Biometric data, as you've already heard, is defined differently in different legislation in the UK. For example, a photograph in UK data protection law is not biometric data, but as soon as you translate that photograph into binary code and apply it to a facial searching platform, it is biometric data. So in Scotland, the definition of biometric data includes all biometrics that the police use. So that includes DNA, fingerprints, photographs, recordings, voice, gait recognition, vein pattern recognition, and so on and so forth. The main types are fingerprints, DNA, and images, as I prefer to call them. In Scotland, we have a statutory code of practice, this thing here, approved by the Scottish Parliament in November 2022, and it's a legally binding instrument that Police Scotland, the National Police Service in Scotland, the Scottish Police Authority Forensic Services, so the single forensic services provider, and the Police Investigations and Review Commissioner, because they have a power of arrest, must comply with. And of relevance is that the Scottish Code of Practice mandates that Police Scotland must comply with MARPA and must comply with GORIN. Other points probably worth making, I think, are that there's obviously been this broader debate in the UK under the last government, the point you just touched on, where the last administration were basically trying to drive a cart and horses through some important safeguards and checks and balances that have been put in place in England and Wales under the Protection of Freedoms Act. This was all wrapped up in the Take Back Control After Brexit agenda, and under that proposal, which fell, the aspect of the England and Wales Commissioner's role that would have went to the Investigatory Powers Commissioner, and I suspect still will, was solely that part about reviewing where biometric data is held from an unconvicted person in connection with a national security determination. The fact that there hasn't been a commissioner in England and Wales since mid-August means that nobody in the UK is reviewing these national security determinations, and that includes Scotland. The point that you you made to the previous witness, there was no plan for what was then going to happen with the rest. So effectively, had that continued, there would have been no oversight in England and Wales of the police use of biometric data, period, and that would have given the police a licence to do whatever they want, and trust me, that's exactly what they would do, was that to happen. So that's the kind of broader context. I mean, I think in terms of Scotland, the role that I perform is a very proactive role. We lay a 4-year strategic plan before the Parliament. We are independent of government. We report only to the Parliament. And every year we pick 1 or 2 themes, and we'll have a deep dive into that theme. So, for example, yesterday we laid a report in the Scottish Parliament that looks at how the police in Scotland use DNA, explains what DNA is used for, why it's taken, etc., and its value in terms of contributing towards solving crime. I think in terms of your own bill, what I would say, and it's easy for me to say it because I'm coming from a different jurisdiction, I think that what you're doing is absolutely the right thing to do. Of course, you should have a biometrics commissioner. The role that person performs has got nothing to do with UK data protection law. UK data protection law is upheld by the UK Information Commissioner, but this is a role about upholding the lawful, effective and ethical use of police data under devolved criminal procedure law. So it's important that you should have your own oversight arrangements for that. I think the one area that I think is missing from your bill is images, as I would call them, rather than photographs, because the fact is that the PSNI probably hold, I think I read online, about 182,000 images. The PSNI, like all UK police forces, use the Police National Database, which is a UK-wide intelligence system, which has within it a retrospective facial matching capability. So you could take an image from a crime scene, you can put it into the PND, and it will wash that image against the images of people who've been arrested from anywhere in the UK. And likewise, the PSNI also use the Child Abuse Image Database, CADE. It has a facial matching capability within that. Now, this is public knowledge, but the point of sharing that with you is that your police service here are using images in a way that would constitute biometric data under any definition anywhere. Yeah, it's absolutely the right thing to do. I think you should have a think about whether you would want to include images in there. The police hold more images than they do any other biometric data type. The UK, for example, holds 7 million DNA profiles, about 6.5 million fingerprint profiles, but way in excess of 20 million images. And why this is important is because when we withdrew from the European Union, under the Trade and Cooperation Agreement, the exchange mechanisms with the EU remain. So the UK as a whole still exchanges fingerprints and DNA on a case-by-case basis with all 27 member states of the EU, and that's a population of 590 million people, I think. And under something called Prüm 2, which is like the next phase, the EU have already passed a motion to add images to that. And in due course, the UK will be invited to participate in that, which is why at the moment the Home Office are energising a piece of work around creating a national UK image database in the same way as currently exists for DNA and fingerprints, and that's to facilitate this international exchange. So, yeah, I would have a good think about that. But otherwise, I mean, I think it's a very good bill. I made a couple of other minor points. One was there was a reference in one of the articles to DNA not changing, but DNA can change. If someone's if someone was, for example, a bone marrow recipient, their DNA will change because they will carry their own DNA and the DNA of the donor. But the more fundamental point that I made in my written submission was, if you don't let the PSNI keep the source DNA sample, and if technology advances, as it always will, they will then be denied the opportunity to reprofile that sample at a later date if they adopt a more advanced DNA interpretation and analysis capability. So it's just something for you to think about.
That's really helpful. And actually, I was going to ask you, I mean, there are 3 paragraphs, just before I bring members in for questions. And before you conclude your remarks, there were specifically 3 paragraphs that I did want you to elaborate on, and that was one of them. The paragraphs to which I refer are paragraph 9, 14 and 15. So if you have anything additional you'd like to say on that, Dr. Plass, would love to hear it.
Well, I was about to stop there, but I'm happy to take questions on any of these points. So just hit me and I'll give you the answer if I know the answer.
All right. Okay. So first of all, I'm going to take the Deputy Chairperson, Deirdre Hargate. Deirdre, off you go.
Yeah, and Brian, thanks very much. And apologies, I can't be there in person. I have a chest infection and I didn't want to smith people. But thank you for taking the time. I just have, because we're keen to just keep the engagement with yourself going. As you say, there is a commissioner in Scotland. And obviously, we have moved on this because of the European Court judgments. And that's, from a rights perspective, we're looking at all of this. So the department currently proposes the year model of 70, 50 and 25. And it's just to get the view from the Scottish experience, the fact that you've been up and running for a short while now. Do you feel that that's proportionate in terms of the European Convention? And, how you approach that issue around proportionality and data retention?
Yeah, no, thank you. It's a good question. I think this is an area that's often misunderstood because the substance of the European Court ruling was not that indefinite retention is wrong. It was that indefinite detention with no prospect of review is wrong. So as long as, and sorry, can I just say, we've actually researched this. We've looked right across Europe. Nobody has the gold standard of retention periods. Everybody does it differently. The UK is probably more draconian than every other EU member state. We take too much of this stuff and we keep it for far too long. So there's 2 separate things here. If you have biometric data from an unsolved crime, of course you're going to keep it forever, in essence. Why wouldn't you? And there's nothing to prevent you from doing that. UK data protection law doesn't apply, for example, to biometric data that hasn't been assigned to a known individual. So, park the unsolved crime stuff to one side. But then, when you're talking about keeping data from people who have been arrested for all sorts of crimes and offences, it's actually a bad idea to have a one-size-fits-all approach. This idea that whether you've stolen a Mars bar or you've killed somebody, we're going to keep your data for the same length of time, which is the approach, or has been the approach in Scotland and in England and Wales. So I think that the retention regime that you're proposing is probably okay, but the bit that could make it not okay is not having periodic review. So that's something that you might want to take advice from on the UK Information Commissioner, who I think, or somebody from the ICO, I think is going to be coming before you. Because under UK data protection law, and it's not my place to speak about that, but it does require, it states that there must be periodic review. We conducted a review of the laws of retention in Scotland last year in partnership with Scottish Government, and we made a number of recommendations to Police Scotland to review their retention policy because they're not Goran compliant and they're not doing what they should be. So one of the recommendations in the reviewing of their retention policy is that it must, underline must, include periodic review, you know. So I think you get into difficulty whether you decide you're keeping data for 5 years, 10 years, 25 years, 75 years. It's kind of arbitrary, because if there is no period, no prospective review within that, then that's where you kind of fall foul of the European rulings. So some kind of review mechanism, that doesn't necessarily need to be in law. The police service could have a retention policy that builds in periodic review. It doesn't have to be in the face of primary legislation. But I think,
Can I just check?
Yeah.
Is that periodic review of the length of time you would keep it, or periodic review of what you've got, or both?
Yeah, periodic review of what you've got. You know, this idea of, you know, if you hold a million DNA profiles, that you shouldn't treat them all the same. You know, you should actually treat Brian Plasto's DNA differently, because the reason that you took my DNA was because I did this. But, you know, it's... and one of the reasons, I should say, why this is so difficult for UK policing is the police in the UK have been taking people's fingerprints for 120 years. And images, photographs as they were then, for more than 120 years. And none of the databases that we now have, whether it's a UK national DNA database, IdentOne, the UK fingerprint system, or local systems, none of them were designed to facilitate weeding based on a periodic review mechanism. So it's not that the police are unwilling to change, it's that they find it difficult to achieve without investment in a technical solution. So that's one of the big challenges.
It's going to be a big challenge for us in terms of the resources that the PSNI has. Deirdre, you've a couple other bits and pieces there.
Yeah, I was just touching on that bit of review and also appeal, because I think this is a critical area, Brian, that I know even the Human Rights Commission here have raised, where they have certainly said, you know, that some of this should be set out in legislation at this stage to ensure that there's clarity. Obviously, there's a history and a legacy here too that may differ slightly in terms of the Scottish experience as well. So it was just from your perspective, and you've said you've already went through an initial review, you know, are there things that we could be looking at to kind of strengthen the current legislation in terms of those reviews, but also that right to appeal as well? And I suppose when you touched on the issue there in terms of the facial recognition and the fact that PSNI already have access to that, do you feel that it's a weakness then that facial recognition isn't included as part of the biometrics? So, for example, if there was a review or an appeal, they hold this data, but if we don't include it, then that could be a weakness in terms of oversight of how the data is being held. So I just want you to kind of, if you could flesh that out a wee bit more in terms, and sorry, the other bit, and this is my last, is just the emergence of AI, and is that going to change things further? Are you alert to any of these new advances in technology as well? And I suppose, you know, how we make sure any legislation that we're doing is future-proofing where we can going forward also. Thanks.
Yeah, I mean, that's one of the significant challenges, is that the legislation by its very nature will never keep pace with technology. I mean, that was actually the reason that the Scottish Parliament opted for a statutory code of practice, because the code of practice can be amended very quickly, whereas primary legislation is quite difficult. To go back to your substantive point, I mean, my view is that it would be a mistake for you not to empower your commissioner with the ability to oversee how the police use images. the databases that I referenced earlier on, the Police National Database and the Child Abuse Image database, they work off AI-enabled algorithms. So when we're talking about AI, we're not talking about something that's coming in the future. We're talking about something that's with us now. And at the same time, when I referenced the Home Office are developing a new UK custody database, as they will, and they're also bringing in a new strategic facial matching capability. This is AI-enabled technology which will support both retrospective image search as exists in the two databases I referenced, but will also support live facial recognition for those police forces which choose to use it. And again, it's never been used in Scotland, and I believe it's never been used in Northern Ireland either. Does that answer your question?
Yeah, no, thank you. That's useful. Thank you.
Are you finished, Deirdre? Thank you. Okay, Danny, and then I've got Morris after that.
Thank you, Chair,
apologies,
and thank you for the presentation. Sorry I can't be earlier. There myself, I'm actually down with a cold as well. I suppose I want to come at this from the angle of children and young people and the retention of their data, and the dangers probably around the stigmatization of young people, and just your view on it and concerns that you would have about the retention of their biometric data.
Yeah, again, that's a fantastic question. I mean, one of the issues in the UK, because policing isn't that different, you know, across the UK in terms of what you're strategically trying to achieve. But one of the problems has been that children, people under 18, have basically just been grouped in with adults. When we conducted a review in Scotland in 2022-2023 into how Police Scotland acquired biometric data from children, we found that they had no distinct policy for children at all. And so we made a recommendation for them to develop that. As a consequence of that, Police Scotland will now only take biometric data from people under 18 if they're arrested for a violent or a sexual offence, or otherwise by exception. There'll always be exceptions, you know. But what that means is, and in Scotland there's about 4,000 under 18s get brought into police custody every year. Most youngsters who come into contact with the police never end up anywhere near a police custody centre. But that change of policy by Police Scotland, you know, a voluntary change of policy, will mean that less young people will have their biometric data captured, and you know, that reduces the stigmatisation thing that you're talking about. But why it's really important is, just to illustrate a point, is when in 2022-2023 we said to Police Scotland, can you tell us how many under 18s you arrested and took DNA from, they could very easily give us an answer, and the number was roughly 4,000. But when we then said, okay, and in these 4,000 cases, when you took DNA in a custody environment, how many times did it match to DNA from an unsolved crime scene? Well, they couldn't tell us. And I suspect that's because the answer was 0. So, yeah. You know, so whilst biometric data is very important, it's actually not a feature in most police investigations, you know. So DNA only helps to solve about 0.34% of all recorded crime. And, you know, if facial imaging technologies will be less than 2% of all crimes. So sometimes it has a really high quality value because it can help to solve some really serious crimes. But numerically, it's not a major feature in most investigations.
Yeah, and I suppose then holding that data would be then, probably in your opinion, then a breach of Article 8 of human rights then, because it wouldn't be proportionate.
Well, that's the whole essence of Article 8. It has to be lawful, it's got to be proportionate, and it's got to be necessary. And, you know, quite often if you look about and you ask your police service if they have a biometric strategy, for example, as we've asked Police Scotland, they don't have one. Right? So, you know, because a lot of these things have been around for so long before anybody called them biometrics, they've kind of, they're not always managed as well as they should be, if that's not the wrong way to express it.
Yeah, no, thank you. And just lead into the last one. So, is there any particular aspects of the Scottish Biometrics Commissioners Act that you would amend or could have been done better, I suppose?
I think the Scottish legislation is quite well crafted in the sense that it's quite an expansive definition, so that kind of future proofs it. The fact that the Scottish Commissioner is appointed by and answerable only to the Parliament is good, because that prevents any political interference. Because I know that every one of the 4 biometrics commissioners for England and Wales, because I've met them all, one of them's unfortunately no longer with us, has been frustrated by political interference in their role. Every one of them has said that not including images in the role was a strategic mistake by the Home Office. So the other thing to mention is the wording of the Scottish legislation. It says that the Commissioner may do anything necessary or expedient to discharge their functions. That's quite powerful words. We have I mentioned the Code of Practice, the Statutory Code of Practice. We have a public complaints mechanism. So if the police take your data in Scotland, not necessarily because you've been arrested, they've maybe taken it because you've been a victim of crime, and you feel that they're holding that data in a way that's contrary to the Scottish Code of Practice, you can complain to my office. And with the Statutory Code of Practice comes powers to serve information notices, powers to issue compliance notices, and ultimately to report something to the Court of Session, which is the highest court in the land in Scotland. I don't think that would ever happen, because the police service are actually very good at listening to suggestions for improvement. So, but I think the legislation is well crafted.
Brilliant, thanks very much. Really appreciate it.
Thanks, Danny. Maurice, I'll take you after Connie. I forgot that Connie was in the queue ahead of you. Go ahead,
Thank
Connie.
you. Chair, it may be something I didn't raise. I wanted to ask a question about, but it's
okay.
something that I definitely learnt from your paper. So thank you so much for coming in today and presenting to us. So I actually wanted to tease out a bit of what you said around DNA can change.
Yes.
And that was something I didn't know before reading your paper, so I really appreciate you raising that with us. I just want to kind of get your assessment of how much of an issue that could be if not addressed in the legislation, and whether you've had any instances in Scotland where this has raised its head, where someone's DNA has changed following a transplant.
Yeah, so this all came up. So it's not a major issue, is what I would start by saying. Everybody's DNA is unique, apart from identical twins. Identical twins have identical DNA. They don't have identical fingerprints, because your fingerprints are formed when you're an embryo and you're moving about in the womb. But otherwise, everybody's DNA is unique, and you get half of it from your biological mum and half of it from your biological dad. About 10 or 15 years ago, there was a case in Alaska where there was a sexual assault, and the Alaskan state troopers matched the DNA to somebody on the North American database. And so they thought, well, this is easy, it's an open and shut case. But the problem was the person that it matched to was in prison and had not been out and could not have committed the offence, and didn't even match the description. And when they investigated it more thoroughly, they found out that the guy who was in prison was a bone marrow donor, and it was actually the bone marrow recipient who had committed the sexual offence. So the DNA that was extracted from the semen recovered at the crime scene contained the DNA of the donor. So I'm just simply making the point that there is no such thing as a biometric technology that's 100% accurate all the time. That just doesn't happen. DNA when a forensic scientist presents evidence on DNA in court, they're always talking about probability rates. And even then, DNA can be problematic sometimes if you get a profile recovered at a crime scene, so you don't have a full profile. That can be problematic if you have a mixed DNA profile, because there are, mixed male and female DNA. That can be difficult as well. So it was just a point to make you aware that this thing, chimeric or recombinant DNA, as it's properly known, does happen. It would be picked up by a forensic scientist in this country, because all of the forensic scientists work to an international scientifically accredited standard. In some other countries, they don't. So you can't always, when you hear about something that happens, for example, in America, because you'll often hear people talk about the Golden State Killer and how investigative genetic genealogy is the way to go. Well, actually, it isn't, because the American police should have been able to trace that person anyway, because his brother was already on CODIS, the FBI database. So, it's complicated, this stuff, isn't it? And it was just really to highlight that everyone's DNA is not unique, because identical twins have identical DNA, and sometimes other quirky things happen in science that means that someone's DNA is a bit more complicated.
Thank you. And I think just further up from that, how do you take that into consideration in practice in Scotland? Is it in your code of practice or is it in your legislation?
Well, you don't need anything in specifically in legislation for that, because there are all of the forensic science providers in the UK have to be accredited by the Home Office, and the Home Office will only accredit them if they're ISO 17025 accredited by the UK Accreditation Service. So you would not have a miscarriage, if it gives you any reassurance, you would not have a miscarriage of justice in Northern Ireland because of that phenomenon. It was just simply highlighting to you that it sometimes exists.
Thank you very much. That's really helpful. Thanks.
Thanks, Connie. Morris?
Thank you very much, Chair, and thanks very much for your presentation. And your accent's actually pleasant to hear, so don't worry about it.
Yes, exactly.
I'm an amateur photographer, have been for 30 odd years, and I'm interested in the progress of AI. Used to be you had to click, 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 click to drop out a background. Now you can do it at a button. And not only can you erase a background, but you can add a background. And I'm interested in the facial recognition, which I think is a good thing. If it was shared, we don't have it here. But as AI progresses, do you see the advances in AI not only in facial recognition, but in body form recognition? For example, how a person walks, how they carry themselves, their weight profile, etc., etc. Do you see that advancing? And the other thing that you mentioned there was political interference. I think when we are going forward, we need to make sure that politicians like us have no input into what comes out at the other end. Absolutely none. We should not be interfering in the process of law and order. And if there's any way that we can enhance the process of law and order, and if that means stepping away from it and letting professionals do it, I'm all for it. And that really is the one question I did want to ask you. You mentioned that facial recognition is accepted by the EU. Has the human rights come back and said that there's anything wrong with what sharing data, etc., 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 across police forces? No.
So the European Court of Human Rights, as you know, is or human. A better way of saying it, human rights is enshrined in European law, and the existing exchange mechanisms for biometric data involving DNA and fingerprints is completely human rights compliant, because it's not there's no bulk transfer of data, you know. So for example, if I was to go to Spain and commit an offence in Spain and the Spanish police recovered my DNA, they could upload that into the Prüm system, and all that would happen is they would get an alert saying that the UK, that's a UK profile. They would then have to contact the UK, and there's a kind of one-way in, one-way out system operated by the Metropolitan Police and the National Crime Agency on behalf of all UK police forces. And the host force, let's say it was PSNI, would confirm that they hold that profile. But then they would say, so what do you want it for, right? And if the Spanish police were to say, well, it's somebody that's stolen a wheelbarrow, you know, they're going to say, well, you're not getting it, right? But if it was, well, it's actually a child abduction, then of course they're going to share that information. So the whole human rights piece is all across all of that. And as I say, whereas the EU do not support live facial recognition, the EU do support the exchange of images by the police and law enforcement agencies for the purposes of retrospective searching, in other words, to wash images from crime scenes against the images of people who've previously been arrested by the police. Does that answer your question at all?
It does, but if you could maybe expand a wee bit on the advances of AI about not just facial recognition, but perhaps body and gait.
Yeah, well, I think one of the big opportunities for policing is in relation to non-generative AI, so AI that doesn't generate content. And it kind of goes back to the point I was making earlier on, which is, in the UK, we've got something like 7 million DNA profiles, 6 million fingerprints and more than 20 million images. And the reason that every police force in the UK has struggled both with MARPA and Gorin is because they just don't have an automated means of applying a retention regime that encompasses periodic review. But that's where AI could help, so you could easily program a set of rules. So let's take, for example, the proposed retention regime for Northern Ireland. You could take that regime and you could superimpose a periodic review period onto that. And the AI could run that, and based on certain criteria, could then push stuff to a human, for a human to make decisions based on the recommendations of the algorithm. So isn't it strange that in our everyday lives, you order something off Amazon, right, and a guy turns up at your door and delivers a parcel, and within a split second you've got an email comes in, that's your parcel being delivered. And yet, when the police try and use this type of technology, it's like, So providing it's, I suppose that's a clumsy way of me saying that there are lots of, AI, first of all, is already used in policing, but there are lots of other areas of policing that are going to benefit from AI in the future. But primarily I'm talking about non-generative AI, so the stuff that still leaves the human in the decision-making process, but can automate a lot of these process. Because with biometrics, if you keep putting more hay on the haystack and it keeps getting bigger and bigger, it becomes increasingly hard to look for that needle in the haystack. So that's where technology can really help you.
Yeah, thanks very much. Thanks, Chair.
Thank you, Morris. Deirdre, can I check before we bring Ciara in? Can I check, do you want it on this particular issue?
Yeah, it was just when Morris asked that question then, it's just when I was thinking there in terms of the facial recognition that you touched on, Brian, but it's just around what protections could be built in to ensure that there's not mass surveillance or targeted surveillance. So we had a case recently in the Investigatory Powers Tribunal where the PSNI and the Metropolitan Police were unlawfully spying on journalists in a bid to uncover their sources. So how would you ensure then the biometrics isn't used for the same purposes, and what safeguards could be put in place to ensure that that didn't happen. So it can get on the one hand in terms of they have access to the systems, as you say, that you said earlier, but to ensure then that that's not used to target surveillance on certain sections or groups within society. What protections or what enhancements could we build in to ensure that that doesn't happen?
Okay, so this is why layers of independent oversight are important. So the police can and do use biometrics in the covert side of policing. Those are not part of my statutory function in Scotland and would not be part of your proposed commissioner's role, because those policing activities which do that are overseen by the Investigatory Powers Commissioner, Sir Brian Levinson and his team. So all the sort of clever stuff that the police can do with biometrics in the covert space and that the security services and others can do, there is independent oversight of that. The issue, of course, is that all of that, there's no reporting on that. And why some of that is important. So if you take, for example, we discussed earlier on that one of the roles of the Commissioner in England and Wales is to oversee biometric data retained as part of a national security determination anywhere in the UK. And each of the previous 4 post holders has reported publicly in their annual report on that, so that they will say how many NSDs they reviewed, how many they've upheld, how many they have challenged. If all of that, as I suspect will happen, gets moved into the Office of the Investigatory Powers Commissioner, it will still be overseen, but we won't know any of that, so we just won't know how many were reviewed or how many were upheld or and so on and so forth, because that sort of oversight doesn't get reported. Does that answer your question? Or
suppose, yeah, to somewhat, it's just, I suppose, an area that we need to look at more carefully, because obviously the tribunal did rule in that case that they unlawfully were doing this, so it's just making sure when we're looking at biometrics, because you do say it is such a sensitive area. And obviously here there's a different dynamic, in terms of our own history, that we just need to make sure then that we're looking at all aspects. Yeah. So, no, thanks for your answer there. It just clarifies a wee bit more for me.
It's probably just worth me adding, if you don't mind, that, there's always some crossover or not crossover, but there are mutually convenient exchanges between various offices. And, I think I said in my written submission, for example, that in the overt space, there's good UK coordination in all of this. So at the moment I mentioned that the fingerprint and the DNA databases at a UK level are managed through this forensic information database service. When we move, as we will, to a national custody image database and sharing with the European Union, that will all come under that same UK architecture. And it just helps because although the international exchange mechanisms are on a UK level, all of the data is acquired, retained, and used and destroyed under domestic criminal procedure law in different parts of the UK. So it's important that we all speak to each other.
Okay, Deirdre.
Yeah, thank you.
Ciara?
Thank you, Brian, for your presentation today. I've just 2 follow-up questions, basically. One is relation to if you could provide more detail on the importance of, obviously, the statutory code of practice that you currently have and that you utilise. And then secondly, I would just be interested to know, in relation to the office itself, what is the annual cost in running the office? And do you feel it needs to be strengthened, particularly in Scotland? with regard and staffing, resourcing, etc., or where that's at? Thank you.
Yeah. I'll start with your second question first. So I have 3 full-time staff, and my budget is just under £500,000 a year. 78.6% of that goes on salaries, pension costs, etc., etc. In my annual report and accounts, because we're a public authority, we have to have our annual report and accounts audited every year by Audit Scotland. And last year, when you strip out the salaries and when you strip out the cost of external and internal audit, we ran our office for about £50,000 last year. So it doesn't have to be an expensive function to maintain. For reasons of full transparency, I also have a chief inspector, a detective chief inspector from Police Scotland seconded to me at the moment. That is for a couple of reasons. One, it's about building capacity and capability within the office, but it was also because we were doing some highly technical reviews. So I mentioned we laid a report on DNA in the Parliament yesterday. It's very technical, and short of doing all the work myself, I kind of needed another person with some good subject knowledge. And then next month we're going to be laying a report in the Scottish Parliament that you might want to pick up on as well, because we specifically look at how Police Scotland are using the retrospective image search technology within the Police National Database and the Child Abuse Image Database. And obviously, excuse me, I can't say too much about that, but it will be worth a read, and that will get laid in Parliament probably the last week in March. And then to go back to your first question, if that covers that point on the finance, etc., the code of practice, I think, as I said earlier on, the reason that Scotland chose to go down the code of practice route, it was actually a recommendation from an independent advisory group on biometric data, chaired by a guy called John Scott, who at the time was a QC, he's now a Lord, he's a High Court judge in Scotland. And his view, which I completely agree with, is that because technology moves so quickly, it's far easier for a commissioner to oversee not just the law, but a code of practice, because you can actually change your code of practice more quickly. And certainly the code of practice that we have in Scotland, and it's a principles-based framework, basically, but it allows you to change things quickly if you need to. And as I say, those to whom it applies must comply with it, and it's backed up by powers of enforcement. So I think it seems to work well in Scotland, is what I would say. There are other, I mean, the police are very familiar with codes of practice. That's another thing worth saying. There are policing codes of practice for almost everything, so it's a language that the police service understands. But I think a code of practice works best when it's backed by some legislation. So in the Scottish case, a statutory instrument, so it has some legal authority.
Okay, Karen.
Okay, thank you, Brian. Just when we follow up, and obviously you had mentioned that the report's going to be laid in relation to the UK database custody images in end of March. Is there anything at this stage that you could throw light on, that it's something that we need to be looking at in relation to this bill?
No, there's nothing. There's nothing in there other than the report will show the direction of travel in UK policing in terms of where all this stuff's going in future, and why it's important that you might want to think about having independent oversight of how the police use retrospective image search, as they already do in Northern Ireland, but also where it inevitably will go in the future should your Chief Constable decide to go down that route.
Okay, thank you.
Thanks, Ciara. Thank you, Brian. I've just got a couple of things that I just want to whiz through reasonably quickly. So, in your view, then, first of all, I want to check just a general premise. Is there a legal distinction between images and photographs? I have in my head what the distinction is, but obviously our bill perpetually refers to photographs.
Yeah, so, listen, I joined the police in 1978 and we used to take photographs of prisoners, right? But they're digital images now, right? It's binary code. And if you just hold that image, that's one thing. But when you then ingest it via the binary code into a biometric template, which is what is in PND and CADE, it is absolutely biometric data. The UK Information Commissioner will tell you, even in UK data protection law, that's biometric data. So that's the first thing. It gets more complicated because in UK data protection law, DNA is genetic data, or it can be in certain circumstances. So there's different ways of talking about the same thing, but my substantive point is that whenever somebody's arrested by the police, all three things get taken at the same time.
Yep.
And so why would you not have oversight of one of those things when it's the most commonly used one?
No, that's helpful, thank you. And presumably then, it would be your view that a service instruction from the PSNI, did they destroy, for example, custody photographs, whenever they're destroying the other elements that are collected at the same time, that's insufficient? It should be covered in this bill.
I think best practice would be if it was in the face of primary legislation, but the difficulty is, and this goes back to the point about your DNA not changing. So, if the police have arrested somebody and they already have their DNA, normally when they arrest them on a subsequent occasion, they won't take it again because they already have it on file. And the same's true of your fingerprints, because, unless you work a lot with cement and things, your fingerprints are relatively static. But your image changes a lot throughout your life, and certain categories of offenders, as we all know, deliberately change their image all the time to avoid detection. So I think the issue is that even if somebody is arrested for something and there are no proceedings or they are found not guilty, if they already have previous convictions, you need to be keeping everything, because that's good practice. And another thing to think about as well is, even if someone is not proceeded against and they have no previous convictions, then of course you would expect the police to remove their fingerprints and their DNA from the national systems, and of course you would expect the police to remove their image from the national systems. But you might still want to keep that image for a while, because the person may, a year down the line, put in a complaint and say they were beaten up in custody. And so having that photograph of them with or without a black eye might be helpful, So while you may not be keeping that data for a biometric purpose, you might still want to keep it for a period of time under, your kind of normal, conventional retention regimes for data.
That's a really interesting point. Actually, it hadn't occurred, and
of course, that would
we
be,
might need to follow
and that would be the distinction about when is a photograph not a photograph. So if it's just the image of the person for a human being to look at, that's one thing, versus the binary code that goes off into the...
And running it through the systems for facial recognition.
Exactly.
Yes, no, that's helpful, thank you. Just with regard to the periods proposed for us, and it segues from your last point, So obviously there's 75 years, 50 years, 25 years, and then there's holding DNA for 3 years for somebody who's not convicted, I think, or charged, isn't it? And then the other, for 3 years if not convicted, and for 10 years after death. Do those appear proportionate to you in terms of what's proposed in the bill?
Honest answer?
Yes.
No. I think keeping anybody's biometric data beyond average life expectancy sounds a bit difficult to justify on the grounds of proportionality. And we have just said in our recommendation to Police Scotland yesterday from our DNA report, because one of the issues there was, and it goes back to my Mars bar or murder point, we asked Police Scotland, look, if someone is who has no previous convictions is found guilty in court of a really trivial offence, and they're admonished or given an absolute discharge, it's still technically a conviction, but the court views it as so trivial that it's immediately spent under the Rehabilitation of Offenders Act. How long would you keep that? How long would you keep their DNA, for example? Well, we'd keep it for 100 years or 3 years after death. I think, well, that's crazy. That just isn't proportionate to do that. So we've kind of suggested to them for those types of scenarios that they might want to think about treating the biometric data in a similar way they would if someone was to receive a fiscal fine or a police warning. You know, one of these direct measures, where in Scotland, Police Scotland would normally keep that data for 3 years, and if the person has no other previous convictions or subsequent ones during that 3 year period, it would then be destroyed, you know. So, you know, that question of proportionality is really important. All these EU rulings are based on considerations of proportionality. So I suppose for me is, I think the periods that you're proposing are fine, providing there is opportunity for periodic review. Would be my take on it.
No, I'm trying to find the balance between retention and allowing crimes to be solved further down the line as intelligence progresses. You know, with
it's balancing human rights and human wrongs, and that's why this is so difficult, and that's why nobody has got this right. There isn't, you know, that we've looked. There isn't a golden model out there that we can.
What are your retention periods?
Well, they're about to change, but in Scotland, Police Scotland have. So the law allows the police to keep it indefinitely.
Okay.
Sorry, the criminal procedure law allows you to keep it indefinitely, but the UK Data Protection Act doesn't, and Gorin doesn't, and MARPER doesn't. Police Scotland's policy has not been based around indefinite retention. They have, at the moment, they have they call it a 20-40 policy, a 70-30 policy, and a 100+. And it's based on your age. So if you're, if you're 20 at the time of the offence, they might keep it for 40 years. If they're 30, they might keep it for 70 years. And if it's a really high tariff offence, for example, 100 years plus. But for DNA, they're keeping it for 100 years. They're not really, because it's only been around for 30 years, but the policy says that they would keep it for 100 years. So as I say, one of the recommendations that was made to Police Scotland, and they're doing it at the moment, is to review that policy, and we've given them till the 31st of October this year to come back to us. And what we're asking them to do, we're not asking them to change any of these thresholds, but we're asking them to come back and tell us how you're going to build in periodic review. And it can be done. It can be done. It's just they might come back and say, "Here's how we're going to do it. Scottish Government, you now need to give us some money because we need a technical solution to support that."
No, I understand. I'm likely we'll be in the same position. Could I ask you, you've brought something to my attention there, and it's just around the issue of the retention of children and young people's DNA, those under 18. Often we have seen, and we know from evidence, that certain behaviours are indicators of potential to engage in serious crime. Is there a risk? I appreciate it's a small number of people, of course, but is there a risk that if that DNA were to be destroyed, it has the potential to impact an ability to solve future serious crime?
Yeah, there is. There's always a risk in everything that you do, and it is this the point I made about trying to balance human rights and human wrongs. I mean, a good example, we actually give, we give in our DNA report that we published in the Scottish Parliament yesterday, some case studies, and there was a really interesting one where there had been a murder in Scotland a few years ago, and they had a good DNA profile from the murder scene, and they ran it through the Scottish DNA database, nothing, and they ran it through the Scottish and UK, no matches. A few years later, the culprit was arrested for a really minor offence, and the offence, the nature of the offence was such that had his DNA not matched to that murder, it would only have been kept for 3 years and then it would have been destroyed. But here we had in our community somebody who was a rapist and a murderer, and probably had done it before, and if not caught, would have done it again. So there is always a risk with these things. And I go back to my earlier point, which is none of these European court rulings prohibit indefinite retention. They just prohibit indefinite retention without periodic review. So as long as you've got periodic review, you could have quite lengthy retention periods, and in some cases you would want to,
Yeah. Yeah, and that's kind of the stuff that I'm interested in, just to make sure that we're not impinging on people's rights to not, and it's finding this, but people are able to solve serious crime going forward, and that's just trying to figure that out. So thank you for that. Is there anything else? Obviously, the national security determinations are also an issue of concern there, but I suppose we're going to have to see how that is borne out, because people from Northern Ireland are also impacted by that.
Yeah, I mean, I had asked that question myself of Home Office officials maybe about 6 weeks ago, just to find out,
Where are we?
And ministers are considering things. So I don't know where that one's going to go. It wouldn't surprise me if the national security determinations went to the Investigative Powers Commission, because I actually think that's actually a good idea anyway. Mm-hmm. Because these are all taken under counter-terrorism legislation anyway, so it's reserved matter. So that kind of makes sense. My worry would be if England and Wales don't then uphold the provisions of the Protection of Freedoms Act. You've got 43 police forces in England and Wales. If you give them a free licence to do whatever they want, they will. So I just feel that having independent oversight is important. It can be a supportive role. My own role in Scotland is to support and promote lawful, effective and ethical use. So you're not like you're not a regulator as such. You're a kind of trusted independent voice, almost like the conscience of policing, to try and help them do the right thing, to help keep people safe and to help catch bad people. So
just find the right balance.
Yeah.
That's helpful, thank you. I have one more question, I'm going to move to Stephen and then that'll be us done. You've addressed the issue around photos and live facial recognition. Could I ask you just, you had mentioned familial DNA, genealogical DNA. Do you have anything else you want to bring to our attention around that?
yeah, I mean, every so often something jumps over the pond from America. So, for example, at the moment there are a number of police forces in England and Wales in relation to the management of sex offenders who are using, I think, let's call them lie detector tests. Now, there's no scientific basis for them whatsoever. You know, polygraph tests, they don't have any scientific validity or credibility. So we always have to be careful about things like that. There is a familial searching capability within the UK National DNA Database, and Interpol has that capability as well. Where it's mainly used is for unidentified bodies or unidentified body parts. There has only been, when I posed the question about 2 months ago, there had only been one UK familial search that had identified a EU subject, and that was an unidentified body in the UK that turned out to be a missing person from the Republic of Ireland. So it's used in a very limited way. The UK only does about 12 to 15 familial searches a year. They have to be approved through the Fines Strategy Board. So that's a strategy board that's chaired by either a Deputy Chief Constable or an Assistant Chief Constable, and the England and Wales Commissioner sits on that group. I sit in that group. The Information Commissioner sits on that group. So it's pretty well regulated and it's not used a lot. The issue with investigative genetic genealogy is that the databases that, if you've ever done this, send your DNA off to Ancestry to find out if you're a Viking or if you come from France, is that you just don't know whose DNA samples are in there, and so it would be, if the police were ever to go down that route, it wouldn't stand up in court, to be honest, because there's no integrity in the system. So I'm not saying it's something that UK policing will never use. They might use it occasionally on a particularly unusual inquiry, but we have so many of our citizens already in the DNA database that the chances are, at the moment, whenever the police in the UK, certainly in England and Wales, if DNA is recovered at a crime scene, then 64.8%, I think it is, don't quote me on the point, it matches to somebody that's already in the system. So, what we, as a proportion of our domestic population, we hold more DNA on our citizens than any other country in the world. So, it's probably not for us.
Yep. Thank you very much indeed, Brian. Stephen?
Thank you, Chair. Thanks, Brian. Just a couple of points. There's been a bit of press coverage this week with yourself just around, you were urging the police, the report you published about urging police to speed up, I suppose, defining, the strategy on the use of biometric data.
Yeah.
And then also just around ethnicity, about police recording, I suppose, taking more efforts. You feel there's a lack of ethnicity data. I suppose I'm just keen to hear a wee bit more about that in terms of linking it in with lessons that we could learn from that particularly. Yeah,
one of the issues here is that, and this applies to all police forces, they tend to be data rich but information poor. So they will hold lots of biometric data, but when you then ask them to explain the utility of holding that data, they kind of struggle to do that. So if you were to say to the police service of Northern Ireland, why do you need retention for 5 years or 10 years or 25 years? They would actually struggle to give you a reason that's backed up by any evidence. They'll say lots of plausible things about, keeping people safe and etc., etc. But police service says generally that data rich, information poor. On the ethnicity point, it's simply that the Fines Strategy Board that I spoke about, they produce an annual report every year, and it gives you a full breakdown of how many DNA profiles are held in the UK. It's broken down by age groups. At the time of being taken, it's broken down by gender, it's broken down by ethnicity. They'll give you match rates. They'll tell you about things like adventitious matches. They'll tell you all about familial searching, everything like that. But in a review in Scotland, when we asked Police Scotland to give us a breakdown of ethnicity in terms of the Scottish DNA database, they couldn't tell us because they don't record it. And our broader point was, well, wait a minute, the former Chief Constable, Sir Ian Livingston, publicly stated that there were problems of institutional racism persisting within the National Police Service. And the new Chief Constable, well, she's not new now, but the current Chief Constable, Jo Farrell, has said that she agrees with that, so it's important that the police service, as part of their sort of public confidence package, are able to demonstrate to the citizens that they police that they're doing that lawfully, fairly, ethically, that they're not unfairly targeting any particular group in society or causing harm to any protected characteristic group. So the media probably made a bigger issue of that than probably we would have, but it's just something we would like to see Police Scotland improve on, because fundamentally our DNA review, it's a good news story, right? It's shown how important this technology is, but as inevitably happens when you have a deep dive into something, you will find things that could be improved. So it's just our recommendations have to be taken within that context of we are trying to support and promote just to make policing a bit better.
Yeah, okay, thanks Brian, thanks Chair.
Thank you very much. Dr. Plasto, can I thank you so much? Your evidence has been really helpful. If there's anything else we wish to follow up on, I presume we can do that with you.
She can, yes.
And thank you so much. We very much appreciate you taking the time to come here in person.
Thank you.
It's been great to have you, and I want to extend gratitude on behalf of the entire committee. It's been really, really useful for us. Thank you very much.
Thanks for having me. It was
Thank you.
nice to pop over.
And if anything else occurs to you, please don't hesitate to submit it in. Us will be very grateful to receive it.
Great. Thank you.
Thank you. Safe trip home.
Thank you.
Members, just before we move on, there's a couple of things that occurs to me maybe we could ask the department. If we could ask them around how they admitted to us that the 3 years was kind of arbitrary. But if we could ask them how they arrived at the 3 years, how they arrived at the 10 years after death, I think it also would be helpful for us to have some understanding as to who exactly the Commissioner would report to and for what. Whether or not is their intention to instigate a code of practice. And also if we could ask the PSNI for sight of their service instruction around these issues and photographs. Would members be content with that? Yeah? Thank you very much.
Yeah, sure.
Yes, Deirdre?
Yeah, no, I would agree with that, but also, sorry, just on when I was going back over the Hansard in terms of the biometric stuff as well, the Human Rights Commission had said that they had made some suggestions or changes, so I would like to ask the department, have they taken them on board, and also to get a list of what proposed amendments the Commission had proposed.
Okay.
And then also then just a view of the department of what they've accepted and what they haven't, just so that we have a rounded view of it. Thanks.
Yep. Sounds sensible to me. Members content? Right, thank you.
Chair.
Yes, Ciara.
Would it also be possible just to maybe ask the department or the minister what consideration they have been given to the single UK database as well of custody images and the report? Has there been any conversations in relation to it, particularly in relation to maybe what impact it could have on the Justice Bill moving forward?
Yes, our members agreed? Yep.
Yeah.
Thank you. Yeah, I think some of that stuff is concerning. It seems to me there's a few issues there we're going to need to follow up. Issues around the potential for DNA to change, the issue about source DNA potentially being lost, whereas technology may advance, and also this business, as you raised here, about Europe, and biometric material being shared there and photographs being shared there. So I think those are things we'll need to pursue with the department going forward. Okay, members can tend to move on, because I appreciate we've got another oral evidence session here. Okay, agenda item 6 then is SL1, the electronic monitoring requirements, responsible officer amendment order Northern Ireland 2025, and we're going to receive oral evidence from the department. Could I ask members to turn to pages 158 to 170 of your packs, please? So members, the committee initially considered the proposal for the statutory rule at our meeting on the 23rd of January, and we agreed to ask the department for further information on a number of matters. We then considered the response at our meeting on the 13th of February, but we had a number of further queries. We therefore agreed to request the attendance of departmental officials for an oral evidence session on the proposal for the statutory rule. So departmental officials are here with us now to provide oral evidence on the SL1 about this electronic monitoring. And I would welcome to the meeting Michael, who have I got with me? Michael and Matt, sorry, I can't see with my glasses or without them, gents, apologies. So Michael McAvoy, who's the Deputy Director of the Community Safety Division, and Matt Neal, who's the Policy Lead for MARA, which is and electronic monitoring. So thank you, gents, very much for coming to the meeting. You'll appreciate we've had a couple of papers in this now and we've gone back and forwards a bit. I don't imagine you've got a general presentation to give us, but it's just to invite any comments that you may have before we raise the issues that we've got.
So, Chair, I did actually. Do you know why? Because it's such a long time since we've really spent any time telling the committee about electronic monitoring. So if you want to indulge us, I'll happily give you a bit of background or go straight to the questions, but I'm happy to give you a bit of background if that's helpful. That's
a decision for members. Members, well, how do you want to play this? You'll appreciate, gents, I'm sorry to have kept you back there. We were receiving evidence on the bill, so we're slightly behind schedule, and my apologies for keeping you waiting. So, members, I'm conscious of time. Do you want some background information, or you can tend to proceed to questions?
I think it would be useful, Chair, just to get a brief overview or background, yeah. Because it might answer some of our questions.
No, that's helpful. In that case, gents, fire ahead.
I'll make a start, Chair. Listen, thank you for the opportunity to discuss electronic monitoring today, and indeed grateful for the consideration that the committee has already given to the electronic monitoring requirements responsible officer amendment order. That's a bit of a mouthful. I genuinely think trust that Matt and I will be able to address the queries that members have. And as I say, the subject of electronic monitoring, or it's more commonly referred to as electronic tagging, it's not something that we've spent a bit of time talking to the committee about for a while. So very briefly, a wee bit of background. Public Protection Branch within the division has policy, legislative and operational responsibility for electronic monitoring in Northern Ireland. Tagging, it's simply a tool that we use as part of our overall public protection regime. And if I just explain what we use electronic tags for, in Northern Ireland they're used to monitor individuals either released into the community in two different circumstances: on bail terms set by a court after a person has been charged with a criminal offence for the police but before they've been to trial, or as part of conditions in respect of a prisoner leaving custody to serve out the remainder of their sentence in the community under the terms of a licence, Chair. Fair to say that they're probably most often used in connection with bail in those two scenarios that I've just given you. At any given time, as we sit here today, roughly 400 people in Northern Ireland are on an electronic tag, and over the course of a typical year, you have about 1,200 people in total that could have been on a tag for a period of days, weeks, or months. So it's quite a dynamic, quite an evolving picture with people coming on and off tags. To be honest, Chair and committee members, when it comes to electronic monitoring, electronic tagging, we're quite behind where we could be in Northern Ireland and indeed where we'd like to be. And I'll say this, it's not a lack of imagination or aspiration on the part of the department. And indeed, we're talking about some aspects around procurement and stuff, and moving to utilise new technology and developing technology in the field of electronic tagging was a key part of the procurement exercise that we've just now recently completed. Matt led that work, and he can provide further details as the committee wishes. Suffice to say, in terms of the contract, there was an absolute need to go to tender as the previous contract had reached its end point, and we used up all of our options in terms of extending that contract. And we've now reached the point actually where, to bridge a gap that we have, we're using direct award contract arrangement. Tendering the contract was also about testing the market to ensure that we were continuing to receive value for money. It's fair to say that whilst the current system works incredibly well, it is limited. The main tags that exist are around electronic tagging are curfew tags and location tags, and we've been using curfew tags for a number of years now to enforce typically requirements for someone's obliged to stay at home, typically 10 o'clock in the evening to 6 o'clock in the morning. There's a base unit in their home, they wear an ankle tag, and then we can enforce that curfew and monitor any breaches of that. As part of the new procurement contract, we expect to be able to appoint the new provider that we've advised you about, and when we go live in the coming months, hopefully, they will initially provide a like-for-like service with the existing provision, but we've built into the procurement specifications a requirement for the new provider to be able to offer location tagging during the course of the next 5-year contract award period. So for the first time in Northern Ireland, we'll be able to avail of GPS functionality, and that opens up an awful lot of possibilities that we'll probably not have time to explore today, but maybe on a different day, Chair. We've also included scope to test sobriety tags and monitor drug or alcohol consumption. In short, we're looking to transform and modernise the service that we currently provide, and the motivation for that's really simple. It's the new technology means we can, when we utilise it during the life of the next contract, it means that we'll be able to significantly enhance the protection of the public. We'll also be able to do quite a bit around the rehabilitation of an offender, and possibly add a tool that will assist crime detection and investigation. Matt and I volunteered as part of the recent testing to wear tags. That's sobering, gives you an insight into the reality of what it involves, but also the possibilities in the more recent testing, user acceptance testing around the possibilities of the new technology that we're looking to tap into. So happy to take questions, and Matt I'll volunteer him to cover the detail because he knows it.
Thanks, Michael.
Thanks, Chair. No, thank you. That's really helpful, actually, and really interesting too, because I presume it'll really help you to manage bail conditions much better and much more closely. Deirdre, I know that this was an area that you're interested in, and it's an area that I'm interested in too. We had some questions. Do you want to go ahead first there?
Yeah, thanks very much. And Michael and Matthew, just for coming in front of the committee. We thought it was easier to do it this way than going back and forward. And I suppose my main concern was, I suppose it's that monitoring and the GPS technology and when that would come in. I have been hearing concerns at a community level that even the past contract has not been working as well as it could. And I suppose it just concerned me when you said there, Michael, that it's a like-for-like service, because we would have complaints certainly from communities of repeat offenders where they're actually out on a tag and they're reoffending, and the impact that that's having on the community. So for me, we would be keen to see what the monitoring within this new contract will look like, how it will differ. You talked about the location tagging and using GPS functionality, when that would come into play. I'm also conscious of, obviously, this company, I suppose the last contract, I mean, we would hear that it wasn't working well. And is that a reason why you did go out to market again to look at elsewhere? Were there issues with that previous contract? And have you rectified any of those issues in this new contract to try and ensure it doesn't happen again? And I suppose, are there review periods built into it as well, that if it's not working, if people are offending while they're still wearing these tags, what kind of mechanisms or function? And I know you said in your correspondence, I mean, we've been asking the current company that's going to be offered the contract, I mean, they're based in England. Do they work here on any other contracts? And, you know, what will the setup be here? Or is it all going to be done via technology, you know, from a remote centre? Or are they going to have a physical presence? And if so, what that physical presence is going to look like immediately, and then over the cycle of the contract as well. So we're just looking at a bit more detail. And as I say, the main concern is breaches of those who are wearing the tags, who are potentially reoffending, and that's a concern coming directly from communities. Thanks.
Thank you, Deirdre. You happy if I take Deirdre's questions now? Yeah. Deirdre, a number of things there. The like for like is simply a reflection of the fact that I'm going to emphasise the current electronic monitoring arrangements are very rudimentary. The radio frequency, all they do is whenever you have an electronic tag on your ankle, you're obliged to be in your home at 10 o'clock. And as long as you stay in your home from 10 o'clock to 6 o'clock, if that is the bail condition that you're obliged to uphold, and you don't leave your home, then you have met the requirements of your licence. Come 6 o'clock in the morning through to 10 o'clock the following night, where you go with that tag and what you do during the day, there's no ongoing monitoring, there's no additional functionality where we can restrict where you go, what you do, which town you enter, whether you go near addresses and stuff. So that is part of the reason why we're keen to introduce over the life cycle of the new contract period the GPS monitoring. So just to make sure that everyone's aware that it is very rudimentary. It is curfew monitoring that we have in Northern Ireland at present. It just makes sure that someone stays typically in their home overnight, and if they leave there's a breach, and then that is reported to the current provider, and then that can be reported to the police, and depending on the profile of the offender, there's a sort of a graduation in terms of the response to what action is taken to go and investigate that. Sometimes there are technical breaches, and there's an initial process. The very first thing that will happen is that the current provider will lift the phone, they will ring the base unit in the person's home. If the person that's on the tag is there when it appears that they have possibly absconded, then that's okay, that's an issue with the technology. They'll still send somebody out to take a look at the kit, and in doing so confirm that that person on the tag is still there and they haven't attempted to tamper with the tag, and maybe that was the reason why it triggered. But it's not terribly sophisticated, but it performs that function reasonably well for those 400 people that typically would be on a tag. So the GPS definitely offers lots of opportunities, and we've explored that. The committee has received a briefing on the bids that the department put into the Transformation Fund, and one of those, you may recall, Chair, was in relation to electronic monitoring. The purpose of that area is to put together a multidisciplinary team, and again, if that bid gets confirmed, we would be expecting to do that from April onwards. And that's a multidisciplinary team to explore how it is and how quickly we could tap into the functionality that's provided through the new contract. So I can't answer the question, Deirdre, in terms of when we might be able to use the GPS. There's definitely going to be an awful lot of work to consider the uses, the applicability, potential cohorts. We've done a lot of work and looked at other systems in England and Wales and internationally in terms of how it is being used and being deployed. There's definitely a lot of scope in relation to domestic violence, sexual violence perpetrators, and restricting their movement. That extends to a scenario that I actually talked to the Interim Transformation Board about in relation to stalking. There's definitely an application there. But in London, they've used it for high-end gangs that target expensive stores for theft. That wouldn't be a priority for us, it would seem, but certainly it's an additional cohort of offenders that you can manage through alerting a central system if they breach a condition where they can't enter an area, a town, or if they head for the border, and they can be live monitoring. I said we're not looking for the Truman Show here, but there is an endless amount of possibilities, and we genuinely just haven't had the time to fully explore where we would best be able to place our efforts. Again, driven by the desire to enhance public protection arrangements for victims and the potential rehabilitation. In terms of review periods, and Matt, you're well across the details of the operation that the new provider will provide. Deirdre, so we ask Matt to maybe answer those questions.
Yes, thanks, Michael. In terms of the contract and sort of how you would review performance, I mean, our intention would be, and I think we might have set some of this detail out previously, but just to break it down, we will have direct live access into the new provider system. That will be the first time we'll have had that direct live feed. We would normally have a series of reports and other things provided to us for billing purposes and really quality assurance and audit to make sure we're getting value for money and that services are being delivered as expected. But within the new contract management process that we'll have with this service provision. We'll have weekly audits of the data, we'll have monthly and even quarterly meetings with the provider, alongside ongoing engagement to look at key performance indicators, to look at performance, to look at any issues, because we're very conscious that we've had a tried and tested system working here. And to be honest, I think no news, it has been good news to a degree that it's been working very well. But for 15 years, there hasn't really probably been a great evolution in what we have. So as we work through a transition and mobilisation period with a new provider, we'll have a lot of regular contact, a lot of engagement, and really be breaking down the services they're providing and taking feedback from citizens that are being tagged, our stakeholders in the police, courts, probation service, and really using that information to manage the contract on an ongoing basis. Now that's the kind of the day-to-day contract management for me. The longer term kind of piece will be, we've built in, the initial contract would be for a 5-year period, but with a logical period of review within the 3rd year. So once the data and the systems are up and running, we would have at least empirical data for 2 annual periods. We would then intend to review it in the 3rd year of operation with a view to looking at the future. So the contract, the way it has been set up, and certainly as Michael says, we've advised of the intention to award. We haven't awarded it just yet. The first contract period is for 5 years, with options to extend for a further 2 and for a 3 and 2 year period. And each of those will provide either organic breakpoints or points to review the contract, review the service conditions, and make any amendments or adjustments as required. But that will be, it'll be an ongoing organic process as this contract moves forward, particularly as Michael says, the service business as usual approach to make sure that we're not creating any ripples in terms of service provision for customers and citizens at the minute as we move the curfew technology on board, but moving into looking at location monitoring and how effective that could be and how that needs to be explored. That will take a longer period of time. So I think the 3-year point is a real good opportunity to review that. And certainly technology, as you know, it evolves every week, almost every day it seems. We'll be looking at that constantly to see what changes have been made, what international evidence can we look at to make sure that whenever we do switch on any new service as part of this, we're getting the best bang for our buck.
In terms of the footprint of the new provider, in terms of their base in Northern Ireland and employment?
Yes, absolutely on that point. So the new contractor has committed to developing a field services hub in Belfast. So I suppose that'll be their base of operations really. Now what that'll look like in practice would probably need to be further developed. But realistically that's going to be where you have your stockpile of all the equipment, all the tagging gear, any redundancies and systems that need to be put in place there. The field staff will be using there as a base of operations. I'm guessing the fleet will probably be based there to allow them to move around Northern Ireland with the equipment to attend home addresses and deliver that. And there'll be an operations manager overseeing all of that. And that will be the dedicated on-the-ground workforce that is based here in Northern Ireland. Aside from that then, you're right, it is a remote service. There will be a monitoring centre and there will be digital communication going to a base likely in England. But there will be day-to-day field staff in Northern Ireland delivering 24/7 provision. And as Michael indicated earlier, alongside going out and installing the tags and removing the tags and the equipment and engaging with citizens to check faults, breaches and things like that, the other side of that will be that they're on the ground to deal with any issues. And if anything like that happens, they can go out and attend the addresses at whatever time we need to meet the demand from, whether it's the court or the police.
And the other thing I'll add to that, Chair, is that arrangement isn't that dissimilar to the system that we have at present in terms of a hub located in...
It is or isn't, sorry?
It's not dissimilar. There is a sort of technological hub across the water, but there is that local workforce and the fleet and the centre and so on. So
You've kind of led into the area in which I'm interested. And I'm not sure if Judy wants to come back yet, but I'm just going to interject a wee second if that's all right. And it's around, you're talking there about, yes, they will have a presence, but originally you had been hoping to initiate this contract on the 1st of March 2025, isn't that right?
Our intention would have been to commence the legislation at that point in March to allow for, I was hoping on the basis of a contract award in early January time. Okay. We're very conscious that obviously the committee need to consider the SL1 and the amendment, and we've engaged with the provider to work out what the transition time frame would look like. So as Michael has indicated, at this point in time there's approximately 400 citizens on tag. And it will be a graduated process to swap out that equipment. Now some of that might organically happen as the court decides somebody doesn't need that requirement, or maybe somebody's been returned to custody, things like that. So We will probably have to shift that date slightly in line with what the contractor can deliver, but we would envisage a transition period of around 6 months from the contract award point.
The point at which they commence,
Delivery?
yes, they will be in Northern Ireland.
Yes.
And does the contract include whatever costings there are going to be around hubs and so on, or is that going to be additional?
Well, that's included within the pricing schedules that we've been provided with, and certainly the evaluation panel would have considered. So the sort of the breakdown that would have been provided in the tender response, and I wasn't on the evaluation panel, but the detail that I've seen is there's cost around setup and establishing that hub and the services, the infrastructure, I suppose, to make sure that happens, and then there would be the cost for actually running the service on an annual basis.
And are these people equipped to service and maintain the equipment, or is that going to be an additional expense, an additional contract? Or
That is all built into the contractual arrangements.
So it's all covered?
Yeah, it is all covered. I think we've bought a full service, I suppose. Now, I think colleagues in the Ministry of Justice, they went for a kind of a different solution. I think they went for a two-stranded approach where they bought the technology from one company and the field services and the staffing is delivered by a separate provider. We have went for kind of a unilateral approach, so it'll be the same provider. The field staff will be employed by that provider. They will deal with the equipment, the technological solutions. I appreciate they may have other services coming into them in terms of contracts, but no, our contract will be with them, and all of the strands under our contract, that's what we'll be reporting against, so the staff and the tech and the infrastructure around that.
Chair, if I just might add, there's also, maybe in line with Deirdre's question, in that transfer, in that transitionary period, we can't do such a thing as a big bang to move 400 people over on a day. You wouldn't want to do that, because if it fails for everyone. So there is a natural period. So you'll have two, the existing provider and the new provider standing up their service, and one moving that service from one to the other over a period of several months. And there's also, we need to build in a bit of time, and the conversation will have started around TUPE and the potential for existing staff employed by the existing provider to transfer over to the new provider, potentially, should they wish. They might find alternative employment with the existing provider. They might want to go with the experience that they have and be valued members of staff with the new employer. So those that just, you just know that naturally takes a bit of time, but that's why there's probably a 4-month transition period. And it's also to avoid that all or nothing. We don't want a situation where we have nothing.
I thought it's been really, really helpful, and maybe the lesson for us is if we've got queries, just bring in a bit sooner. We can have a conversation rather than perpetually write, and maybe we could move things through a bit faster. That's been really helpful. Deirdre, is everything you needed covered? I see Ciara's got her hand up.
No, just quickly, just to ask, is there a break period in the contract? So say if they weren't doing everything that you'd hoped they did do, is there a break period for the contract? My other bit is, in the contract as it is at the moment in terms of that transitionary period, or to explore the GPS, is it written into the contract then, if you decide to do that, that there's the ability to transfer over to GPS? So it's just really on those two issues. And sorry, my last one was, is there anything additional you built into this contract that maybe it was learning from the previous one? So things that maybe didn't work as well, that you've now looked at or added to this one?
I'm going to volunteer to take maybe your last couple there. It definitely was built into the new contract, and we have actually tested with the new provider. I mentioned that a tag that I used as part of the user acceptance was a location tag. I was told not to go to North Belfast during the course of that week. I turned up at the probation board. I hadn't got out of the lift before they were on the phone saying, what are you doing in North Street? So we have done the user acceptance testing. So, and to be fair, that technology they have deployed, the company has used it in lots of other locations. So really they can provide it to us just as soon as we are ready to take it, and whenever we have considered the implications of using GPS and how it'll work, and ensuring there's no infringement of people's civil liberties and human rights. And there's lots of considerations that we just, to be honest, haven't had the thinking time to work our way through. But that's part of the transformation bid and the potential for a multidisciplinary team to think their way through that. Yeah, and in terms of if things fail, Matt, what's your backup plan?
So in terms of the contract, so the SL1 amendment as it stands will afford the department 2 responsible officers and 2 providers. So that would cover that transition period that we've discussed. In terms of breakpoints from the contract, so It'll be a standard public sector civil service contract with all the terms and conditions and breakpoints around key performance indicators, termination in the event of any issues and critical failures, along with periods and opportunities to look at resolutions. Appreciating the fact that there's also service credits built into this, that there will be certain kind of key milestones and points that the provider has to hit to meet our standards, and that's around the time frame it takes to report data on breaches back to the police, the probation board and so on, making sure that the information on people's behaviour or lack of is provided to the authorities, that can then be dealt with. So within the contract there will be the regular breakpoints, but we'll also be having those contract management meetings on a monthly and quarterly basis as well to keep a track of that. So I don't think, I would envisage that we don't get to a critical point right away in terms of like a difficulty. I think we would be gradually, especially being very, very cautious. This is a new contract and a whole new service. That transition period will allow us to do a lot of things. As Michael has touched on as well, we've completed significant testing on this. We've tested the curfew technology, we've tested the location monitoring technology. So I think part of the answer to Deirdre's question, the location technology is there. It's ready to go. We're Northern Ireland probably isn't ready to take it on board just as yet, and we do need to work through how that works in practice, because it's the difference being with the curfew technology specifically. Curfew technology tells you if somebody is where they're supposed to be at the time they're supposed to be there. Are they at home or are they not there? The location monitoring is obviously live time, direct feed, depending on what the organisations or agencies require. And that will be a lot more intensive, I expect, for a lot of the criminal justice partners. So working that through, but a very specific requirement of the contract is that location monitoring will be provided for. And we're so keen in looking at that and exploring that at a future point. We've already designed the service credits around that to make sure it's responsive to the needs of agencies.
I'm sorry, this is my last, it's just while you were talking there.
Really conscious of time at this point.
Around the location, but does this company, they have that, are they using that elsewhere that we can learn from as well in terms of the pros and cons of it?
Yes, I mean there's a lot of international evidence on location monitoring in general with many providers. Specifically this company that we've already indicated, they are delivering a variety of different services, not just in the criminal justice space, but the Mayor's Office for Policing and Crime in England is utilising their service. I believe currently they'd initially piloted it for up to, I think it was up 200 offenders, all of whom who'd committed offences involving knife crime. So they've already demonstrated, and I think that contract has been extended and renewed post the pilot stage in terms of the evidence coming in there for 200 offenders being GPS monitored throughout their period of supervision. So there's really a direct sort of UK evidence base there, but internationally there's a wealth of evidence in terms of how GPS can be used, could be used, and maybe how it shouldn't be used. As Michael says, our project for that will be to look at all of that to make sure that we're getting kind of the best and avoiding some of the pitfalls.
There's certainly really good examples in the States, Colombia and New Zealand that we've already looked at as part of the consideration of this.
Thanks very much.
Thanks, Deirdre. Ciara?
Hi, thank you, Matt and Michael. I've just 4 really short questions. First of all, regarding key performance indicators, I would like to maybe just get an idea of what they are. Secondly, just in relation to the curfew tags and the location tags, would location tags potentially, you no longer need them, the curfew tags? Is there technology there that location would replace curfew tags? Thirdly, just in relation to, you mentioned about 400 people roughly a year, either on bail or on licence, but 1,200 over the lifetime of a year. What would be the breakdown in the percentage of people between those on bail and those on licence? And then just fourthly, you mentioned in relation to the pricing schedule of the contract, was it clearly outlined within that pricing schedule how many field staff would actually be employed in the north to deliver on the contract? So thank you.
I'll start and then Matt will. It's a demand-led service, and even the existing contract has fixed costs and variable costs. So we do projections on an annual basis as to what it might cost, but it really does depend on how many times someone is been required to have an electronic tag as part of a bail condition. That varies. We obviously, from experience, know where it typically sits, but it increases and falls during the course of any given year. In terms of the location tags replacing curfew tags, I suppose the location tags would allow someone to have a more sophisticated regime. So they might be required to maintain overnight with the same tag. So they might be required to stay at home from 10 o'clock to 6 o'clock. During the course of the day, you could prescribe through the technology that they're entitled to attend a place of study or a place of employment, or simply say you're allowed in Greater Belfast, but you're not allowed to go to Ballymena because you know there's a prior victim that lives in that town. So there are various restrictions that you can place through the use of location monitoring technology. And I say we just haven't got there in terms of what those bail conditions might be or the specificity of those. What we have tested is that they are absolutely, the technology exists to allow very specific bail conditions to prevent people from, my example of don't go to North Street and you turn up on probation board and they're on the phone, it's very specific in terms of what the breach that you will trigger. Matt, maybe talk about the KPIs from the contract. And the percentage from bail and licence, I'm going to go with 90-10, and Matt's going to correct me. Matt.
Yeah, thanks, Michael. So I took a snapshot really from the 17th of February, just after the committee's last consideration of the SL1. So at that point in time, 17th of February, there were 86% of the caseload on bail, with the remaining 14% then being on a licence with probation. And that was out of 350 at that point in time. Just for interest, a bit of gender split as well. It's roughly 90% male, 10% female, if that's of any interest to the committee. In terms of the KPIs that we have at the minute, there's a couple of very specific ones, and it's about mobilising the service in line with the contract date, which obviously we'll agree, and then they'll have to hit that. A secondary element that we have in one of the KPIs is around a digital solution for the ordering system. It's a bit nuanced, but effectively the system we have at the minute is forms are filled in by the court staff. They're checked against the orders of the judge and they're emailed through to the provider. We want to replace that with a digital portal solution to really streamline things and allow for more robust cross-checking of information, and that'll speed things up, particularly when you have an individual perhaps going through a court for multiple offences and maybe they're on bail for 2 of them but not for 1 with an EM condition, to make sure that everything stays on or drops off at the right time. Other KPIs, and I don't have everything in front of me, apologies. Some of the KPIs will be around the percentages at which things are dealt with. But for example, 90 or 95% of calls being made by the provider to the individual within 5 minutes of a breach occurring, or within 15 minutes, depending on the specific nature of the breach. So that could be if they've breached their curfew, it could be with the location tags in the future, if they haven't charged the battery, they'll get alerts around, well, you haven't charged that, it's at this percentage, you must charge, but they'll follow up to that. So it's very prescriptive, Ciara, in terms of the performance, effectively, the ongoing performance of the provider to meet the needs. The monitoring centre as well, the beacons, or the hubs that are fitted at the home, that's a two-way communication with the citizen as well that's on tag. So in the event of an emergency or an issue, they can contact the monitoring centre and flag that. If they contact the monitoring centre by using that direct access, that call has to be picked up within 60 seconds, things like that. So that's some of the KPIs we have around ensuring that that level of performance is dealt with. At a rudimentary level, when the order is placed by the court, making sure that the tag is fitted within a certain number of hours. We don't want to put a tag install order through on a Monday and somebody's not tagged to the Thursday. So it has to be a very robust, dynamic service to deal with the demand, predominantly, as you say, 90% of it from the court. Well, Michael's just touching on the second question that you had around the curfew location tags. I think one of the best ways that, and having worn them, the location tags are a bit bigger because they have all the bells and whistles in them. They have a big battery in them as well that allows for battery life, especially when you're monitoring somebody moving through the cities or the towns, and it'll do the curfew, but it'll do all the location monitoring as well. So you know where they are at any given time, and you can set on a digital system they're supposed to be in this zone on the map at this particular time, and if they're not, alerts go off. They're not supposed to be near this address at any time in the case of maybe a victim or a co-defendant, and the alerts will go off. So it's a much more evolved and responsive system to look at different risks, and certainly a big step up from what we have in the curfew monitoring. You touched on the pricing schedule, and I think we covered the metrics as well. Yeah.
It's just in relation to the field staff. It's quite vague at the minute, just, in your presentation was envisaged. Have we any numbers, and was that included within the pricing schedule of many field staff we would have here in the north?
To run that system on the initial like-for-like, you'll need, and you have people that have to go out in the middle of the night if there's a breach and so on. So you're talking probably up to 20 staff. That's the basis which the existing provider provides the service, and the new provider, to create that like-for-like from day one, will have to have the people employed and on a shift pattern so it's kind of self-identifying the numbers of people they need to be able to respond to the existing demand, and also to flex that, and in the future they'll have more staff if we have more people on tags and more sophisticated tags when we move to location monitoring. So the likelihood is that we'll have more people. It'll not be 400 and 1,200 over the course of a year. That will grow if we utilise that additional functionality in the future. And as that grows, they'll need more staff. That's just the way we envisage it working.
Okay, thank you.
Thank you very much, gentlemen. Thank you very much indeed. We very much appreciate your time today, and apologies for keeping you back.
Not at all. Thank you.
Thank you. So members, can I ask whether you're content with the proposed statutory rule, or if there's any further information or clarification you need? And I think that's been fairly comprehensive. Are members content?
Enough, yeah.
Thank you. I want to move through all of this fairly quickly now. Agenda item 7 is Justice Bill written papers. Could I ask you to turn to page 171 of your pack? So a number of written papers relating to the Justice Bill have been included in the meeting pack for consideration by the committee. The first 4 are responses from the Department of Justice. That's item 7.1 is a response regarding vagrancy. Item 7.2 is a response regarding part 4 of the bill on the administration of justice. Item 7.3 is response regarding part 2 of the bill in relation to children and the interpretation of serious threat to public order. And item 7.4 is a response regarding the tabling of departmental amendments. Cathy, is there anything you want to add, or no, you're content? Are members happy enough to note the responses, or is there any further information you require or want?
What do you note?
Thank you.
Noted.
Items 7.5 and 7.6, just a reminder that we had issued correspondence directly to a number of stakeholders regarding the call for evidence on the bill, and while many are going to respond via citizen space, submissions are also likely to be made directly to the committee. Item 7.5 is from Homeless Connect, and item 7.6 from the Simon community, and these were received in response to the call for evidence. Are members content to note the written submissions at this stage and consider further when the call for evidence is closed? Thank you. Item 7.7, members, is during the sightlink demonstration at last week's visit, court service officials advised that the Lady Chief Justice had issued guidance on physical, remote and hybrid attendance, which applies across all court tiers. Given the relevance to the Live Links amendment, a copy of the guidance has been included at page 205 of the meeting pack for our information. Are you content to note the guidance and consider further at an appropriate time in the committee's scrutiny of the bill and amendments? Thank you. And can I ask also, are you agreeable that items 7.1 to 7.7 are published on the committee's webpage? Members agreed? Thank you. Right. Item 7.8 is a draft letter to the editor at page 208 of the pack, and it suggested that this is issued to daily and regional media titles around the midpoint of the call for evidence. There's a couple of stylistic changes that I want to make to that, but it won't in any shape or form alter the material meaning of the letter. Are members agreed to that? Thank you. Item 7.9 is a request to provide NIACRO the opportunity to present oral evidence to the committee on the Justice Bill. Our members agreed to take oral evidence from NIACRO at an appropriate time in our scrutiny of the bill and amendments. Yep. Deirdre, are you coming in there, or are you just indicating yes?
No, agreed. Just now.
Right. Agenda item 8 is Police and Criminal Evidence PACE Codes of Practice, outcome of consultation on revised codes. So, members, this is page 211 to 778 of the pack. Just a wee reminder that at our meeting on the 30th of May last year, the committee noted plans to consult on proposed revisions to 8 PACE Codes of Practice and a proposal to introduce a new code. Revisions were required because Westminster legislation changed or introduced new police powers relating to terrorism or national security. The report and the consultation is being provided by the department, and that's in your packs, and the department states that on the basis of the responses received, it has reviewed the codes, engaged with the PSNI and taken advice from the Departmental Solicitor's Office. It has amended the codes as outlined in the consultation report and provided the revised codes of practice A to H and the new code of practice I. Are members content to note the report and the revised and new codes of practice, or do you require any further information or clarification? Deirdre?
Yeah, sure. It's probably this, and then I'm assuming the next SL1 pertains to this.
Does, yes.
I would just be keen then before, I mean, I would have further queries before I even would agree or look at the SL1, if members are content. I mean, the main body of the report again talks about the Human Rights Commission, and in terms of some considerations that they have given, but it doesn't give detail on it. And I'm just conscious when we are looking at the justice bill that we're doing at the moment, department officials had told us at the start that there were no issues raised, but then when the commission came in, there were. And I'm just conscious with, as you say, the extensive nature of these new codes, I would be keen to hear from the commission, just in terms of the suggestions or recommendations that they made before we then, decide on the SL1 if we could get the Human Rights Commission in front of us regarding this, if that was possible.
My view on this, my view on this is I think we should be hearing from officials. It's huge. These are not small issues, stop and search and all that. None of that is small. I think we should, and actually we've seen how productive it can be to hear from officials around some of these issues. So my view would be bring the officials in, let's have a conversation about it. And if it takes 15 minutes, well, sure, that's fine. But we require some information on there. Deirdre's proposing also that we would hear from the Human Rights Commission on that. Are members content with that approach, and will defer then taking a decision on the SL1 for now until we get further information? Ciara?
No, I'm content with that. I suppose just if we are going to have the departments in, I would like to have a wee bit more information around the 16 campaign interest groups. Because it didn't list, it listed 6 core groups that responded, but it didn't list the other groups. So just a wee bit of more information around that as well. But I agree with the proposal. Yeah, thank you.
Members agreed then?
Yeah.
Yeah, thank you.
Agreed.
Thank you. Right, agenda item 10 then is SL1, the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunals, Order Northern Ireland 2025, that's page 789. The Department's proposing to bring forward a statutory rule to extend for a further 6 months the provisions to allow a court or tribunal to receive evidence wholly or in part through the use of live links, so long as it's satisfied that it's in the interest of justice to do so, and permit a court or tribunal to make arrangements for all or any part of a hearing being conducted by live link to be broadcast for recording, broadcast or for a recording of the proceedings to be made. It's proposed that the rule be subject to the confirmatory resolution procedure. Are members content with this rule, or do you need any further information? I mean, this is just a regular extension until we get the bill through. Are members content?
Content?
Yeah, thank you. Can I also have your agreement now to take agenda item 16, which is in the tabled pack, as the next item of business? That's relates to the Crime and Policing Bill proposal for an LCM. Members content?
Yeah.
Thank you. If I ask you to turn to page 24 to 42 of your table pack for the relevant papers, you'll see it corresponds to item 11.6 at page 829 of your meeting pack. There's also relevant papers here. The committee received notification yesterday that the Crime and Policing Bill was introduced in Westminster on the 25th of February. The bill contains a number of provisions which relate to devolved matters for which legislative consent will be required, and these are detailed in the correspondence from the Department. The Minister is engaging with executive colleagues and, subject to their agreement, aims to lay the memorandum at the earliest opportunity. In noting that the Speaker has asked Ministers to be mindful of Assembly procedure, the Minister hopes to lay the memorandum within 10 working days as set out in standing orders. Given the timescales involved, the committee has been asked to advise within 7 days if it is content with this approach and to indicate if it is content in principle for a legislative consent motion to be sought on the measures that have been extended or applied to Northern Ireland. Do members have any comments? Deirdre?
Yeah, it's just the usual that you would prefer to scrutinise legislation, and just with an LCM, things could change at a Westminster level that is out of our control. So it's just really to put that on the record and to reiterate it. I mean, I can understand some of the issues that the department lines out why they want to take an LCM route, but it's just really to highlight that again, Chair, that we would prefer to scrutinise an actual bill.
Well, there's a couple of points I think that need to be made. One of them is that the department had indicated to us that they couldn't give us further information on this because of confidentiality. But in the course of their correspondence, and it's in the full pack, it turns out that they've been liaising with the Human Rights Commission. I'm struggling to understand how it's feasible to have dialogue with the Human Rights Commission but not with the committee, where things have been brought to this committee in confidence. That confidence has been respected. So I would like to have some understanding around that. The suggestion is that departmental officials are invited to provide oral evidence on this matter at the earliest opportunity. There are big issues contained in here again. We don't know about the potential for amendment and so on over there, and it'd be worthwhile, I think, to hear, because presumably the officials have had those conversations with their counterparts on the mainland. So we've been given 2 options, members. Oh, the other issue is we're not clear whether they're asking us to agree to the contents, the approach and contents of the LCM in principle, or just agree to the approach in the LCM in principle. So I think we would need some clarity around that as well. So we've got 2 options. One is to be content in principle for legislative consent to be sought in respect of the provisions outlined in the department's correspondence, or if any information is required, or if we're content to reserve our position until further information has been received or oral evidence from departmental officials. My view would be option 2, and we'll hear from officials on that. That would be my preference, but I'm at members' disposal in this regard. Deirdre?
I would agree with your proposal, Chair, just to get the further clarity and reserve our view on it until we receive that.
Okay, so
if that's an oral evidence, then even better.
Okay, so our members agreed then that we would move towards hearing oral evidence as quickly as we can on this LCM. Agreed?
Yep.
Thank you. Agenda item 11 is correspondence. There's correspondence memo and 17 items of correspondence at pages 802 to 865 of the pack. I'm going to draw your attention to one of the items, and then as usual I'm going to open the floor for comments on other items of correspondence in which any members of particular interest. The item to which I'm going to refer initially is item 11.8, which is correspondence from the department at page 834, and that's a consultation letter informing the committee of the Minister's intention to seek the agreement in principle of executive colleagues to a proposed UK government statutory instrument to extend the power in section 2 of the Private International Law Implementation of Agreements Act 2020. Are members content with the department's approach? Or do you have any comments on this? I struggled a bit with this, I must say. Does any of the officials want to elucidate a bit? I mean, or do members understand what this is and they're happy enough?
I'm happy enough, Chair.
Yeah.
So we're just agreeing. Does everybody understand it? You know, I don't want to be agreeing to things that we don't understand just to get it done.
Sure, it would be good to get a bit more information, or to kind of break it down. I think, didn't we look at this previously? There was something came through the committee a while ago, or am I thinking of something different? But I think it'd be good to get a bit more detail if that was possible.
I think so too. I'm not fully grasping this. Is it? Sorry.
Yeah, I was just going to say, Chair, there was actually something recently, Deirdre, it was court rules actually to implement some of the Hague agreements, which is probably along these lines. I think it fell out from the Act as well.
Okay then. Can we just seek a bit more information? Yes? Thank you. It's going to be a fun pack next week too. for a couple of weeks' time. Does anybody have anything else from correspondence? I've got a couple of things. There's your response. Obviously, we had sought what the guidance was that had been issued to the prison service with regard to transgender prisoners. That's at page 815. To my mind, there is a glaring gap in the guidance that has been issued, and that is, in the course of their risk assessments, there's no mention whatsoever of a risk assessment to other prisoners. And I think that's a glaring hole. We have seen in other jurisdictions, particularly Scotland and England, that predators have used this to gain access to female prisons. So I think that we should write back to the department and express some concern that wider risk assessments for other prisoners hasn't been borne in mind in terms of the guidelines, purely for the sake of, I appreciate that the requirement to keep transgender prisoners safe, but actually there is an issue here about those who would use these guidelines and the issue of transgenderism for predatory purposes, because they've been charged with and are undergoing trial and so on for sexual offences. Deirdre?
Yeah, no issue seeking further clarity, Chair, but it's just in terms of, I mean, I'm conscious it says in the report that the guidance was drew up, I suppose, in consultation with the Equality Commission and the South and Eastern Health and Social Care Trust. So I'm conscious it's probably not an issue that has arisen here, albeit you're entitled to ask, and just to really see how this sits, I suppose, with the safety of prisoners across the board, you know, from any other prisoner, not really mattering what their kind of sexual orientation or characterization is.
Yes.
But is this in line with the other guidance? So just to get further information on that.
Yeah, the issue, that's not the issue for me here, Deirdre. The issue for me is, look, there's learning from other jurisdictions about what happened where rapists, people charged with and convicted of rape, were put into a female prison. And they still had all of their genitalia, and those people presented a risk. They used transgenderism to gain access to a female prison. So if it happened in other places, I think there is potential for it to happen here, and we should have learning from that, and at least something in place should the need arise. And that's why I'm pursuing this issue, because I think we need to be careful about this, and we should be learning from the mistakes in other places. So, are members content? Thank you. There's another issue. The responses come back about sickness absence. They have not answered the questions that I asked, and I would like to write again asking the questions that I asked, because they haven't responded. They've answered some question, but not what was asked of them. Are members okay with that?
Yeah.
Then there's an issue around the K9 review, and you'll note that now, if I can just find it, what page is that on?
819.
819. They're going to have a review of some of this. Yeah, there's going to be an annual review to assess SAR capacity and capability gaps, explore solutions, including emerging technologies and new practices, and determine the best course of action. Any identified gaps will be evaluated to decide whether they require an expansion of NISAR membership, or if they can be addressed by enhancing the services of existing members. I think we should be seeking to be kept up to date on this, just so that we can understand exactly what's going on in the world of search and rescue and understand the processes. Would that be, are members content with that?
Yeah.
Thank you. Then there's...
Chair,
Yes, Ciara?
could I just, because obviously I had raised it the last time and I didn't really get an answer. I still feel uncomfortable regarding the current practice where it's those in that group who are delivering services are also, based on a gap analysis, deciding who should be included to deliver a service. I just find a conflict of interest. Now, I would hope that's going to be part of the review and update, and if we could clarify if it is.
Yeah, I would also like to have some understanding of remuneration. If we can, I suppose, query that too.
Yeah.
What do I say? What's next? Yes, there is reference in there to, there's a letter in there from the Bar Council. They had originally sought to meet with us. Can we just ascertain whether or not that's still the case? And then you'll note there's a couple of items in there that relate to issues with the PSNI. I'm wondering, I think it's not good practice to just ignore people when they write to us, but this is not something really that's in our gift, and maybe we should just send it on to the PSNI and the Policing Board for comment with the person who wrote to us with their consent. Deirdre?
Yeah, I was going to say the same thing, Chair. It's better going to those agencies that can appropriately deal with it, and I'm not sure whether the Ombudsman's Office would be included or not, but just whatever the appropriate agencies are for it to be referred on.
Members agreed?
Yeah.
Thank you. Agenda item 12 then is the forward work you can tend to note and action where appropriate the other items of correspondence as set out in the memo, or is there anything else anybody wants to raise? No? Thank you. Agenda item 12 then, forward work programme. There's a proposed...
Sorry, Chair.
Yes?
I wasn't sure the one on the children and young people there looking at the paper on organised crime. Do we need to agree that, or?
I think that's further down my list, isn't it?
No.
11:15 is up on the correspondence.
Yes, Deirdre, what page are you on just?
Sorry, I'm on, it's on the correspondence 11.15.
But that's
Page 852.
for action.
Yes, Deirdre, yes, we need to agree whether or not we're going to do that, because that's what part of the action is. Are members content to send on that paper, or what's your view on that? Keir, do you want them the same issue, or is it a separate issue?
No, it's a separate issue.
Okay.
And the one to Professor.
And the one to Professor McKeever.
No harm.
Content to send on?
Yeah, I don't think, it's the Children's Commissioner, so I would say particularly where it pertains with children and young people's issues, yeah, to let them have it.
Yeah, I think the issue here is if people ask us to follow something up and then we do it, I think a good practice would be that we would go back and tell them what we've got and what we've discovered, and obviously we'll agree whether or not we should send on the appropriate documentation, but I think that would be good practice. Yes, members agreed? Okay, Keir, you have a separate issue?
Yeah, it's just two issues basically in relation to the bar, and obviously we got a detailed kind of breakdown of what has been happening to date. I suppose I just want to re-emphasise how critically important it is for the department to have proactive engagement with the bar and trying to find resolution. I'm just wondering, has there been any, or if we could ask, has there been any further meetings since the 18th? And then just secondly, just in relation to Advice NI and the correspondence 11.11, I suppose it's critically important, obviously, this area of work, and obviously immigration practitioners and how they could be currently impacted. I think it's would be useful if potentially we could get a briefing down the line, maybe from Advice NI. Because I think the immigration and asylum legal advice, I know myself through my office, it is quite intense. It's very resource intensive as well. And we don't have very many providers actually providing that. So if there is an ongoing impact, it might be useful, or even a written briefing from Advice NI on that, if that would be possible.
Immigration stuff. And are Advice NI involved in that, or is it all legal practitioners, Ciara?
Well, obviously the TO heard from it at Advice NI, so they're probably core to it.
Okay.
And to do a written response on behalf of all others.
Okay. The first question there is then about the bar. Ciara, just reiterate your proposal again, please, about the bar.
Just basically asking, has there been any further
updates? Okay. Are members agreed to that?
The 18th, yeah.
Yep. Members agreed?
Yeah.
Thank you. Then So this with, first of all, with regard to advice NI, you content to proceed down that route? Agreed or not? Yes. Do you want oral or written?
Both. Possible.
Do you think so? I would be
Well,
going
nice
for
to, nice to
written
hear
on
what
that
they
one, I
what they
think.
talk about before they actually, and then when they present.
Chair, I think it'd be useful even written in the first instance,
Mhm.
and then from that we could make a decision then.
Mark, are you happy with that? If we get a written
Yeah.
one first and then see what we get out of it, and then if we
Everything
need to
will be
proceed. Aye. Well, if we need to proceed, then we can, and if we
Yeah.
don't, we're sorted. Right, members agreed? Right, thank you. And again, item 12 is still the forward work programme. That's page 867. Are you content to schedule the proposed items of business from the department in the work programme? Yep. And then there's an updated forward work programme for us at page 866. Can I seek your agreement to proceed with the sessions and the draft forward programme subject to any changes as agreed during today's meeting? Or just as necessary as we move through it, because sometimes in the course of a week things can change. So are members all right with that? Thank you. Agenda item 13 is chairperson's business. I'll ask you to turn to page 876 of the pack. We had requested the Policing Board's views on the recently published independent review, and the Chief Executive of the Board has confirmed this will be shared with the committee when it's agreed. The Chief Executive has also invited the committee chairperson and deputy it's easy for me to say, the committee chairperson and deputy chairperson to an informal meeting with the chair and vice chair of the board should be arranged in the coming months. That's the standard thing we've agreed to quarterly. Can I ask you to note that? Thank you. Any other business? I've got one issue. Does anybody else have anything?
Nope.
The other issue I have is that I met with the prisoner ombudsman. That's Darren Jones, who's just recently been appointed. So Darren has indicated his willingness to come at some stage and give us a briefing on the work of the prisoner ombudsman and the changes that he's going to implement. I mean, my view is let him settle in a bit first. We've got plenty on our plates for now. But would members be interested in hearing at some stage from the prisoner ombudsman? Yes? Yeah. Thank you. Agenda item 15 is date, time, place of next meeting, and that's going to be next Thursday, which is the 6th of March at 2 p.m. in here. Ladies and gentlemen, thank you very much. Meeting adjourned.
Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound.